County Planning and Zoning Commission hearing. I'm Greg King. Before we get underway, if everyone would please join me in the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. And at this time as well, please, everyone, take your electronics out, mute them, or turn them off for the duration of the hearing, whichever it is, so that they are silenced for the duration of the hearing. First order of business will be approval of the February minutes. Can we go ahead and get a motion on the floor? Thank you, Mr. Elder. Do we have any changes, edits, updates to the minutes from 2025? One second. Ms. Kraus, go ahead.
Okay, page 5, the 5th bullet should say the traffic study does require a left turn lane from Commerce Parkway. However, Oldham County is having a traffic study done for Commerce Parkway. And we would recommend that instead of building the turn lane, they contribute an amount toward future improvements to Commerce Parkway. And then based on preliminary calculations, the cost of the turn lane may be approximately $50,000. And then on page 6, the very last line, it says county attorney, and it should be county engineer Silliman.
All right. Thank you, Ms. Kraus. Anybody else? I don't have a second yet. Can I get a second? Thank you, Mr. Marsh. All right, discussion. We'll go with voice vote. All in favor approving of the minutes, signifying with signification of the changes noted by Ms. Kraus, signify by saying aye. And opposed, like sign. And February minutes are approved. Ms. Fisher, tell us about the December minutes.
All right, so your December 10th minutes were approved at that January hearing, but upon taking the Oldham County Entertainment Center to fiscal court, we realized there was a few errors in those minutes, and mainly it was at the end of each section where it said which commissioners voted for and against. It said approval of a zoning map amendment on all of them, and there were obviously waivers and things like that. So we got that changed to take that to fiscal court, but that was simply the only thing that was incorrect. So we would just like to get a motion to make those changes to those previously approved minutes from December so that those reflect the correct motion.
Thank you, Mr. Fisher. Any questions? Mr. Hampton, is that you? Motion to approve? Thank you. Do I have a second? Mr. Marsh, thank you. Discussion. Again, voice vote. All in favor, please signify by saying aye. Aye. And opposed, like sign. And the changes to December minutes are approved. All right, next up, first docket of the day. Ms. Edgar, can you please read the docket? Do we need to discuss the tabled item, Mr. Baxter?
We do not, Mr. Chairman.
Thank you. Okay. Let's go to 008. Thank you.
Docket PZ-25-008, an application has been filed by Triple Springs Partner for a preliminary subdivision plan for 93 single-family lots. The property is located at 10201 Highway 329 Prospect and is 156.4 acres and zoned R2 Residential District, AG1 Agricultural District, and CO1 Conservation District.
Thank you, Ms. Edgar. Staff, let's go ahead and get you sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. And Ms. Barge, you'll have staff's presentation.
Yes. Good morning. Anna Barge, Senior Planner. I'm here today to present the Triple Springs LLC Pine Grove Subdivision Preliminary Subdivision Plan. So this is the docket that Ms. Edgar just read. An application has been filed by Triple Springs Partners for a preliminary subdivision plan for 93 single-family lots. Property is located at 10201 Highway 329 Prospect and is 156.4 acres zoned R2 residential, AG1 agricultural, and CO1 conservation. So those are the zonings that I just went over. The existing land use is agricultural and residential. The proposed number of lots is 93, and the total acreage is 156.4. So the pre-application meeting was on December 11th, 2024, with the neighborhood meeting being on December 16th, 2024. The two TRC hearings were on January 15th, 2025, and February 19th, 2025. With the agenda posted on February 27th, 2025, adjoining property owners notices were mailed on March 5th, and the public notice appeared in the Oldham Era on March 13th. So for the site history, in November of 2024, a minor plat was approved, creating the 156.41 acre parcel being considered today. So this is the plan presented, and I'm just going to use the mouse here to kind of show, since it's always hard to see up here. So this is the road that goes this way and then this way with a cul-de-sac here and then a cul-de-sac here, and then it wraps back around with a cul-de-sac here and one of those half cul-de-sacs there. And this is just slightly more zoomed in. So anyway, the parcel outlined in red is what's being considered today. And this is the zoning map where you can see the CO1 zoning in the back, the AG1 zoning in the middle, and in yellow, the R2 zoning in towards Covered Bridge Road. So the Oldham County future land use map predicts the use of this tract will be agricultural/rural. The proposed plan appears to be in conformance with all zoning and subdivision regulations and does not have any waiver or variance request. So no portion of the current subdivision plan being considered today is in the 100-year floodplain. And then I also included the TRC comments in your packet. Those are from both the January and the February meeting. So the applicant is proposing a preliminary subdivision plan comprised of 93 lots on 156.4 acres. And already went over the zoning with the R2 being at the front closest to Highway 329, with the rest of the property being zoned AG1 and CO1. So here are the regulations regarding R2 zoning. And without sewer in all of our zonings, it has to be at least an acre. And the agricultural zoning, and the CO1, which basically reflects the agricultural zoning regulations. So to continue on with the notes, the access to Pine Grove subdivision will be via Highway 329, also known as Covered Bridge Road. Typically, KYTC, or our Kentucky Transportation Cabinet, likes new driveways or new roads to be right across from existing ones, if there are existing ones, so that you don't have offset intersections. So based on the school board's calculations, they have a really fancy formula, which I can let the representative for the school board talk about, but they determined that this subdivision can have 35 lots per year based on their calculations. So just an overview of this, it's 156.4 acres, 93 lots with a net density of 1.5 dwelling units per acre, which is sufficiently below, a lot less dense than what we could have on this property. So the applicant is requesting, in summary, the applicant's requesting approval of the preliminary subdivision plan for 93 lots across the 156.4 acres. So we have a few proposed binding elements. We have the one that's on all of ours, which is the approval only applies to the plan presented at today's March 25th, 2025 Oldham County Planning Commission public hearing. That means if they decide to change their plan, they will have to come back to y'all for approval of those changes. There shall be no subdivision of any lot into greater number of lots without the review of y'all, the Oldham County Planning Commission. The preliminary plan must comply with all state, federal, county ordinances and requirements at the time of construction approval. 35 lots per year are allowed per Oldham County Board of Education. And lastly, the developer must follow KYTC requirements related to roadways and traffic. And do y'all have any questions for me?
Questions for Ms. Barge? Commissioners? No? Mr. Silliman, do you have something to add?
Good morning, Jim Silliman, Oldham County Engineer, 100 West Jefferson Street. If you read the TRC minutes, this will be a regurgitation of a lot of that, but I think it's worth it for the audience and a record. Typically, this is a typical subdivision that's going to disturb greater than 1 acre of land, and as such, it will require a stormwater quality management and erosion control permit from my office at that time. If this is approved and they choose to go forward, they would submit that application, and we'll review construction plans that will include more detailed design, including the stormwater detention basins that are shown preliminary right now. At that time, we'll also require that they provide the KYR10 permit from the Kentucky Division of Water. Anna already mentioned the requirement for KYTC and the encroachment permit, since this proposed entrance would encroach on a state right-of-way, state road. We also noticed there are two blue line streams, potentially jurisdictional waters of the U.S. If there's impact to those streams from this development, they would be required to provide either the permitting or appropriate correspondence from the Kentucky Division of Water and the Army Corps of Engineers indicating that they've satisfied their requirements. And again, we would require that at the time of our construction plan review. Let's see. With regard to the traffic impact study, there was a traffic impact study dated February 13th that was provided. We haven't received, or I haven't received any notification from the Transportation Cabinet if they have reviewed that, but that was, I think, the purpose of the binding element that Ms. Barge stated, indicating that the regulations of KYTC should be observed. We did see that in the traffic study, it stated that there would be some impact to the roadway. However, I think based on the level of service and the capacity analysis, left turn was not being recommended. We also look at these issues from a safety standpoint, not just capacity, and safety being intersection sight distance down the road. And while, again, this will be the authority of KYTC to finally review and approve the entrance, based on my observation, based on the topography and the alignment of the road, there didn't seem to be an issue with that safety. Other than that, I'll just be available for questions.
Thank you, Mr. Silliman. Any questions for Mr. Silliman? Mr. Douglas, please.
Mr. Silliman, I think you meant, but I don't want to correct you, but did you mean that the right turn lane was not warranted at this time? Because that's what the report says on the,
Let me get into
you said left, but on her report it says left turn lane warranted.
You talking about
Page 19.
on TRC?
So, and that's where I'll let their traffic engineer explain this a little more, but the way we look at this is there's a couple different measures. There's the level of service, and then there's also this traffic warrant diagram that you're looking at on 19, and it shows that a right turn lane is not warranted, a left turn lane is. What this shows, this graph shows, and when I read the Department of Highways design manual, is that it shows I guess I'll read that for you, that the value is recognized if that dot is located to the right of the curve. It's shown that there's a 2% potential for an opposing vehicle, a left turn, and an oncoming vehicle. So it recognizes a value. I think we've discussed this before in previous cases, that the word warrant may not be the best use of that word, because it's not saying it's warranted, it's saying it's valued. And then the engineer is going to look at the capacity we look at the safety issues
issue.
and combine that all together.
Okay. I do want to follow up on, in your TRC comments, you mentioned some concerns about, or you did talk about that the cul-de-sac length was extended beyond. Was that
Yes,
correct?
and that was really that whole paragraph was included in that letter, really for record keeping, because when we go back and forth in the regulations, sometimes the definition of those gets confused, and we wanted to clearly indicate, so if we had to go back to this, at a later date, to understand that we did not have an issue with those lengths, because they've included that eyebrow and the curve to satisfy those length requirements. It's not necessarily notable, it was more of a record exercise for us.
Okay, thank you.
Mr. Douglas, you good? All right, further questions for staff? All right, Mr. Silliman, thank you. Anyone else from staff? All right. Mr. Williams?
If I could,
No, sir.
just those
No, sir.
documents we were asked to submit.
You'll have your opportunity.
Good morning, all.
Have you sworn yet?
I did.
Okay.
I was
Name and address
sitting
for the
over there.
record?
I'm just
Okay.
not normally in my normal spot. As Anna stated, it was granted 35 per year based on the capacity, and I will be around at least for a little while to answer questions if you have any.
Thank you, Mr. Williams. Questions of Mr. Williams, commissioners? All right, thank you, Mr. Williams. All right, anything else from staff? All right, we will move into presentation from applicant, at which point afterwards you will have the floor. Mr. Swansburg, do we want to go ahead and get your team sworn?
Yes, sir. And just for the record, Mr. Chairman, members of the commission, Mr. Baxter, Mr. Fisher, Ms. Edgar, good morning. Mike Swansburg with the law firm Swansburg and Smith, 117 West Main Street here in LaGrange. I also have with me a number of members from the Triple Springs Partners group who own the property here. And we've also got a couple of folks here. I'll just have everyone stand up who may talk. I don't know that everyone will talk, but just for the sake, Mr. Chairman, of making sure that everyone gets that opportunity to take that oath right now as opposed to doing it later, I'll just ask everyone on my side who might talk to stand up and be sworn in, please.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? I do. Thank you.
All right. Good morning again, everybody. I have the privilege of representing Triple Springs Partners, LLC, which is the applicant and the owner of the property that is before you first thing here this morning. We're going to talk about our request, and Ms. Barge did an excellent job in terms, as she always does, in terms of actually presenting what it is that we're looking for this body to do ultimately. But as usual, we want to come up and talk to you again just to reiterate some of the points we think are important for your consideration. And again, the applicant here in this case is coming before you all to seek approval of a preliminary plan for an upscale residential development to convert the property that you see on your screen highlighted in red to this, which is already what you have seen through Ms. Barge's presentation. It's the Pine Grove subdivision located off Kentucky Highway 329 in Prospect, without, I need to emphasize, without the need for any waivers, any variances, or any changes to the zoning map here in Oldham County. We'll talk a little bit about the proposal. And again, Ms. Barge talked a little bit about this. I want to make sure I emphasize some of the points here. The first one is, I read somewhere that there was a possibility of 300 developments or spots here, just as an example for this proposal. And I just want to make sure that I go ahead and clarify what actually is trying to occur here. And what we're proposing in this subdivision are 93 lots. 93 lots located on 156.4 acres, all of which is zoned in a mix of R2, Ag 1, and CO1, which Ms. Barge already put on the screen, and I'll be happy to show you again if that's what you all would like to see. The lots range between 1 and a little more than 5 acres, as Ms. Barge already indicated, but the minimum lot size throughout the entirety of the subdivision is 1 acre, the minimum lot size. So we don't go any lower than 1 acre, which is required for the regulations, which creates what we call a low-density proposal. That's not an official term. That is our description of this particular subdivision. By way of comparison, however, the property zoned R2, which again is part of this subdivision, but for general purposes, R2, which is described as low density by the Oldham County Comprehensive Zoning Ordinance, can have a maximum density of 3.63 dwelling units per acre. You can put at least 3, if not 3.5 houses on an acre in an R2 zone. And we're not coming anywhere close to that. Not coming anywhere close to that. You may have seen it before, 1.53 in terms of our density. Guiding standards. And as you all know, as being a lawyer, what I like to do is I like to talk about the standards by which this body generally looks to adhere to when they're looking at these types of proposals, the limitations in which we all try to make sure that we fall within when we're talking about these types of proposals ultimately, and what it is that we really should be focusing on today. If I'm going to be really honest with this body, I think it's much more straightforward in terms of proposals than some might have been in the past or some might be in the future. So let's talk about the standards. Oldham County Subdivision Regulation, Section 3.2 provides that the commission, quote, may approve the preliminary plat at any of the steps in which they are involved, end quote. Section 3.2. Importantly, I want to make sure I emphasize this point. Quote, mere generalization of matters to be considered in approval of subdivision plats is not sufficient. There must be rules and regulations constituting specific standards to be applied in determining whether approval is to be granted. And the power of a planning board to approve or disapprove plats is limited by those rules and regulations. That's Snyder versus Owensboro. This is a case out of the Kentucky Court of Appeals, which is the precursor to the Kentucky Supreme Court back in 1975. So in other words, the commission must rely upon the standards set forth by Oldham County, particularly through the fiscal court, when considering a subdivision proposal and approve an application that meets those standards. It can neither approve nor disapprove a subdivision based upon popular opinion. So when we look at a proposal at the end of the day, there are a set of standards that the county has set forward for this type of process. And that is the process that this applicant has gone through and that we ask that you all adhere to when we're talking about this today. Okay, so though not exhaustive, I've listed a couple of points from the Oldham County Subdivision Regulations, sections 1.2A through K. There's a list in the regulations that set forth the following guidelines when considering subdivision development within the county. 1, to guide future growth and development patterns in Oldham County in accordance with the comprehensive plan. 2, to protect the character and social and economic stability of Oldham County while encouraging orderly and beneficial development. 3, to protect and conserve the value of land throughout Oldham County and the value of the buildings and improvements upon the land, and to minimize the conflicts among the uses of land and buildings. And 4, to ensure that public facilities are available and will have sufficient capacity to serve a proposed subdivision upon its completion. Those are what we believe to be a number of standards which will help or inform our discussion here today. Let's talk about that comprehensive plan. The proposed Pine Grove subdivision, I would submit to you all, comports with the Oldham County Comprehensive Plan, particularly 1, through land use objective LU-1-1, which ensures that future land uses are compatible with surrounding land uses. They're compatible with surrounding land uses. 2, land use objective LU-1-2, managing development in areas of environmental concern. We believe that this plan also does that. 3, land use objective LU-2-1, assuring that adjacent development is sensitive in both design and environmental impact of historic sites, neighborhoods, and districts. And 4, community facilities and services goal CF3, which increase efforts to minimize effects of stormwater runoff by encouraging creative site design. That's not it, though. In addition to that, we would submit to you that the subdivision adheres to other parts of the comprehensive plan, namely Community Character 2A, which identifies, recognizes, and protects existing historic sites. Environmental 1A, which limits development in floodplains specifically near Harrods Creek. Environmental 1A, other subsection, limiting pollution, stormwater, and erosion caused by development along Harrods Creek with the creation of buffer areas. And for Land Use 2, which requires future land uses to be compatible in scale, character, and form with existing development. So I've given you 8 parts of the comprehensive plan at this point that we believe this particular plan adheres to. Okay, so let's talk about compatibility and consistency with surrounding development. I want to highlight a couple of areas for you. First, Hidden Falls. It's a subdivision in Oldham County that's about a half mile down the highway from the proposed Pine Grove subdivision. Hidden Falls consists of single-family homes, as best I can tell, falling between multiple 1 and 2 acre lots, give or take. And it also utilizes a septic system similar to the proposed Pine Grove subdivision. That red arrow on there shows you the distance between where Hidden Falls is located and where the proposed property is up to the northeast corner there. 2, the overlook on Covered Bridge. Again, just about a half mile down Kentucky Highway 329 to the west of the proposed subdivision before you. And the overlook also consists of single-family homes falling within, as best I can tell, multiple 1.5 to 5 acre lots. The overlook also utilizes the septic system similar to the proposed Pine Grove subdivision. 3, Neville Mead. Neville Mead is also located about a half mile down Kentucky Highway 329 to the west of the proposed Pine Grove subdivision. It consists of, as best I can tell, single-family homes falling within a multiple 1.5 to about 6 acre lots, give or take. And that subdivision also utilizes the septic system similar to the proposed Pine Grove subdivision. And 4, there's Constantine. Constantine's literally next door to the Pine Grove subdivision plot. It's next door to it. It's on the eastern border, consisting of single-family homes between 2 and 10 acres. And it's also utilizing the same septic system similar to, what Pine Grove subdivision is proposing to use in its subdivision. Let's talk about infill development. The Oldham County Comprehensive Plan encourages, their word, encourages infill development, which, quote, utilizes the existing service infrastructure and lessens the economic cost of expanding utility lines and transportation networks. That's on page 51 of the Oldham County Comprehensive Plan. The proposed Pine Grove subdivision meets the requirement permitting the utilization of existing infrastructure already utilized by at least 1, 2, 3, 4 nearby or adjacent subdivisions. Pine Grove is right here in blue. And you've got all of these subdivisions utilizing the same systems right here in the middle of it. What the plan discourages is leapfrogging of proposals, right? So for example, you just put a subdivision here and then you randomly put a subdivision there and then you randomly put a subdivision over there. What it encourages the county to do ultimately is to approve projects that infill. So you're actually trying to minimize the amount of services that are being utilized across the county. We believe that this proposal, in fact, meets that requirement. Environmental impact. Environmental impact. Septic concerns. So there were some issues raised at the TRC, and I believe there's some issues that have been raised in some comments that may have been filed with you all for consideration about septic concerns. And I want to talk about that. Oldham County Subdivision Regulations, Section 7A states that, quote, on-site sewage disposal systems may be permitted in areas where public sanitary sewers are not reasonably accessible. We allow septic systems to occur in places where public sanitary sewers, what you might think of traditionally, are not reasonably accessible. Moreover, for any proposed subdivision utilizing on-site systems, direct quote, the Oldham County Health Department shall review the general suitability of the site for on-site sewage disposal systems prior to commission action. The Oldham County Health Department gets to come on your property and decide whether or not the land that you have there is appropriate for a septic system proposal, if that is what you're proposing to do. They're the ones who get to come on your property. And in this case, that's what they did. The Oldham County Health Department, Charlie Ward, as the representative of the health department, conducted an on-site soil evaluation of the area, digging approximately 40 holes throughout the entirety of the plat, and found the soil throughout, quote, entirely provisionally suitable for septic systems. And you don't have to take my word for it, it's in the minutes. That's in the minutes that were provided from TRC. Charlie Ward says preliminary soil evaluation was conducted, consistent again with the subdivision regulations, and the findings indicate that the soil in the area was entirely provisionally suitable for conventional subsurfacing discharge septic systems. And also, all the test holes were more than adequate with suitable soil depth for conventional lateral field installation. So again, Charlie Ward, on behalf of the Oldham County Health Department, the body that is charged with making this determination, went out onto this property, dug about 40 holes throughout the entirety of the property, and determined that it was suitable for this purpose. Stormwater runoff. So another issue that has been raised is stormwater runoff. That is a concern, and Mr. Silman's already talked about it, the fact that they'll have to get a permit, assuming this plan is approved. For this purpose, subdivision regulation section 7.7 also requires that, quote, every subdivision shall provide satisfactory drainage and accommodation of stormwater runoff in accordance with the Oldham County Stormwater Ordinance. Consistent with that ordinance, as you can see on this map here, and this is a blow up of the proposal. And you've got two drainage basins here, just alone. These are just two. There are actually more throughout the plat. I just picked two that were easy to see right here and actually highlight for you. But consistent with that ordinance and the comments and input from the county engineer, the proposed subdivision includes multiple drainage and detention basin easements for this very purpose. It's actually built into the plan. We talk about putting in drainage detention basins for the purpose of capturing stormwater to limit its impact on surrounding properties. And to be sure, this subdivision will adhere to a standard that is as high, if not higher, than Constantine, Neville Mead, Hidden Falls, and the Overlook Covered Bridge, which are all within a half a mile, none of which, as we can tell, appear to have similar detention basins designed to capture stormwater runoff. This plan is going to hold itself to a higher standard than everything around it in terms of stormwater runoff. It's built into the plan, as you can see. Proximity to Harrods Creek. That's another concern. Environment 1A of the Oldham County Comprehensive Plan encourages, quote, the limitation of pollution, stormwater, and erosion caused by development along Harrods Creek with the creation of buffer areas. I've put it on the screen for you all. This blue line is my really crude attempt to actually show you the northernmost barrier of the property. It's pretty darn close. And it actually shows you that the proposed subdivision does not extend all the way from Highway 329 to Harrods Creek. There's a big section right here that is not part of this development. In case anyone's looking, this is Constantine, the lots of which go right up to Harrods Creek. In this sense, we do not. I want to talk about something that's surely going to come up. It has come up in the TRC. It's come up in some questions. Let's talk about preserving history and the Jaeger House. So for everyone's benefit, in 1982, the owner of the Pine Grove Farm, so the previous owner of the farm, applied to place, there was a home and outbuildings built by Presley Jaeger between 1843 and 1853 on the National Register of Historic Places, which is managed by the National Park Service. I've got on my screen here, this is the first page of that application. The home and outbuildings were officially placed on the register on June 17th, 1982. The application, however, did not seek the designation for the entire acreage of the farm. As you can see, it talks about buildings And later on, it talks about actually what those buildings are, the house and the outbuildings, old slave quarters. What does it mean to be on the registry, though, on the register? The effective listing, and I've actually highlighted for you that portion of the federal regulation. Under federal law, the National Register serves as a guide for government authorities and citizens to identify worthy historical properties that should be protected from destruction or impairment. Of is not should be there, should be or impairment. That said, federal law, specifically 36 CFR 60.2, and I've got it here on your screen. This is a PDF of the federal regulation, states that, quote, listing of private property on the National Register does not prohibit any actions which may otherwise be taken by the property owner with respect to the property. Listing it on there does not prohibit a private owner from doing what a private owner wants to do with a piece of property unless they are receiving federal assistance for the property. You don't have to take my word for it. If you want, you can go to the National Park Service's website, National Register of Historic Places, FAQs, and it actually says the same thing. Owners, non-federal owners who own a piece of property are not prohibited from altering or even destroying a property so long as they are not receiving federal assistance for the property. In case anyone's wondering, though, here's the good news. The Jaeger House, the plat you see before you contemplates that the continued existence of the Jaeger House and the old slave quarters. It's right here, lot 78. It's included on lot 78, which is 2.8 acre parcel resting at the northernmost boundary of the proposed subdivision. I've got it on your screen there. If you've got the big copies in front of you of the plan, you can see it. It's right here. This is the house. These are the proposed slave quarters, or not the proposed. These are, in fact, the old slave quarters. Sitting on lot 78, 2.8 acres. I created a slide because I want it to be emphasized for everyone's benefit. Triple Springs Partners, LLC, has every intention of preserving the Jaeger House for future use. It has every intention of preserving the Jaeger House for future use. I'm going to summarize. I really think it's this straightforward. Provide the summary. Triple Springs Partners, again, ladies and gentlemen, respectfully asks the Planning Commission to give final approval of its preliminary plan to construct the Pine Grove subdivision without the need for waivers, variances, or amendments to the zoning map in Oldham County on the basis that the plan comports with the Oldham County subdivision regulations, because the plan, among other things, one, adheres to the comprehensive plan's admonitions to ensure complementary and compatible growth with other areas, which I demonstrated to you in terms of its proximity to at least 4 other subdivisions in that area, all of which have consistent layouts and consistent requirements, if not lesser requirements than our proposal. B, limit the impact on the environment through approved septic systems and stormwater retention efforts. And again, we have gone through every regulatory requirement in terms of having the, the county health department show up on the property, dig the property, and make sure the septic systems were appropriate. And in addition to that, stormwater retention efforts are built into the plan because we have to ensure that we address that issue. And as far as we can tell, at least within a half mile, we're the only ones who are doing it. Protect historic sites to the extent practicable. And I've already talked about the fact that Triple Springs Partners has every intention of preserving the Jaeger House and slave quarters to the extent practicable for future use. 2, it protects the character and social and economic stability of Oldham County and promotes orderly and beneficial development. Again, we talk about infill development being a requirement and an encouraged approach for subdivision development in this county. This plan does that. It meets all the other requirements in terms of what is asked for a proposal. It protects and conserves the value of land throughout Oldham County and the value of buildings and improvements upon the land, and minimizes the conflicts among the uses of land and buildings. Again, literally next door to this property is a subdivision. Literally next door is a subdivision. This is compatible with that adjacent use, in addition to the uses all within a half a mile. And also to utilize public facilities which are available and which will have sufficient capacity to serve the proposed subdivision upon its completion. Again, the idea here is, particularly when we talk about that infill encouragement, is that we're utilizing systems here in Oldham County in an efficient manner. We are ensuring that the county is not running up significant bills to support a project that is out in the middle of nowhere, leapfrogging other developments. In short, I want to make sure I emphasize this point. The proposed subdivision meets the requirements for approval with no need for any discretionary act on the part of this body. There is no need for any type of discretionary act by this body. There are no waivers. There are no variances. There are no changes to the zoning map, which makes this decision a ministerial act we would submit, which compels approval. And again, that's spelled out Snyder versus Owensboro, 528 Southwest 2nd, 663, Kentucky Court of Appeals, the precursor to our Kentucky Supreme Court back in 1975. This really is, ladies and gentlemen, a straightforward plan. It doesn't ask for anything out of the ordinary from most any other proposal here in Oldham County. With that, Mr. Chairman, I am done with my initial presentation. I suspect I may have opportunities to talk later, but I will be more than happy to answer, or the team with me would be more than happy to answer any questions of you or the commission. Thank you very
Thank you,
much.
Mr. Swansburg. Nothing else from applicant? Okay.
Not at this time, sir.
Thank you, Mr. Swansburg. All right. This time we'll move into testimony and questions by those opposing the application. Yes, ma'am. Oh, excuse me. Before we move there, anyone else present wishing to speak in favor of this application? Anyone present wishing to speak in favor? All right, seeing none, we'll move into testimony and questions by those opposing the application. This is testimony and questions. You will have 50 minutes. All of those present who would wish to testify, I'll need you to go ahead and stand and get sworn, and when you approach the podium, we'll collect names and addresses.
We ready?
Raise your right hands.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
So we understand there are a number of folks who might be speaking. You guys get to figure out how to use your time. For this, you do have 50 minutes.
Good morning, members of the commission.
Come closer to that mic so we can pick you up on record, please, and we'll need
Okay.
your name and address for the record.
Right. My name is Rick Greenberg. My address is 2321 Lime Kiln Lane, Louisville, Kentucky, 40222. I'm an attorney. I represent Hewitt and Sue Brown and Karen Winter. They are adjoining property owners to the proposed development. You have a stack of documents in front of you. They've been entered into the record already, but I request that the commission be allowed to review those documents during our presentation. The proposed planned development should be denied. It detrimentally impacts the receiving resources. It impacts the neighboring area and the facilities, the nearby streams, the ponds. It causes flooding, encroach upon conservation easements that cause erosion, and it's not in character with the area, and in violation of the comprehensive plan and in violation of many regulations. I'm in here to introduce 3 experts who will testify to many of those items which I just alluded to. There will also be others who will speak to address other detrimental matters of this proposed development. But prior to me introducing those experts, I want to enter something into the record that maybe we shouldn't even have this hearing right now, due to the fact that there are waters of the United States located on the property. There has been a filing of an approved jurisdiction, a request for approved jurisdictional determination with the United States Corps of Engineers. And what this does is require the U.S. Corps of Engineers to make a determination that they're waters of the U.S. and how they would be affected by the development itself. I believe it is too soon to have this hearing, and that the Corps of Engineers may come up with a determination that will significantly change what this plan is set forth to do. The first expert I called to the podium is Ward Wilson, P-E-B-C-E-E. Mr. Wilson is an expert in stormwater management, natural restoration, conservation. He has considerable technical regulatory knowledge. Mr. Wilson managed projects in stream and wetland permitting, stream and wetland mitigation, watershed studies, stormwater permitting and management, and ecological restoration. Mr. Wilson has been a program manager for the Louisville Metropolitan Sewer District Wet Weather Water Quality Program. These projects he addressed included stormwater, water quality, sewer overflow, and Mr. Wilson also managed a variety of water resource projects for many clients, including construction and maintenance of stormwater infrastructure and watershed management planning with local, state, and federal agencies. He is a board member of the Kentucky Waterways Alliance. He's been on the board of a representative of the American Academy of Environmental Engineers and Scientists. He's also been on the board of Jefferson County Soil and Water Conservation District Board. He is also has been chair of the Kentucky Biodiversity Council. And I would like to call up Mr. Wilson.
Hi, I'm Stephen Houston, and I'm an attorney also representing Sue Hewitt and Sue Hewitt Brown.
And your address, sir?
Sorry?
Your address?
Yes, 10801 US Highway 42, Prospect, Kentucky 40059. I apologize, I didn't mean to speak at this moment, but I needed to confirm that out of a courtesy and a request, out of an abundance of caution, we placed documents that have already been filed timely to the record in front of all commissioners, and they have access to them right now, just like they have access to all the other records. And so I noted that I think there might be a concern that you're able to pick them up, just like you're able to pick up the other records. But I wanted to confirm to you, we simply placed them like that out of an abundance of caution. We were told they would be entered and that you would be allowed to review them throughout the course of this hearing. Thank you.
Thank you. Commissioners, those are materials in front of you. And yeah, everybody's free to have a look. I speculate when I say that I believe there will be references made to some of these documents as we move through testimony. I don't know, might be. Nevertheless, it's there for you if you wish to refer. Mr. Wilson.
Hello, I'm Ward Wilson. I have reviewed this development from a water resources perspective. And I have three concerns.
Can I stop you there?
Oh, you need my address?
I need your name and address,
Okay.
your address for the
All right,
record, please.
all right.
Yes.
I didn't know. Ward Wilson, and my address is 1578 Cherokee Road, Louisville, Kentucky, 40205.
Thank you.
Thank you. Good morning, and thank you for having us here. All right, so I have three issues to discuss real quickly. And the first one is the increased runoff that will occur on this site from stormwater runoff. That is because there will be a large increase in the impervious cover on this site from the proposed development. Cover is roofs, roadways, anything that prevents water from soaking into the ground and promotes it running off. There are detention basins, I know, that are proposed to manage the runoff, but that will only reduce the flow rate, not the amount of runoff, and not address some of the quality issues. So what runoff causes are problems in the stream channel from more flow. There's going to be erosion and bank loss. There'll be land lost because of that erosion. There will be reduced flood storage in those streams downstream. There will be water quality impacts. You'll have muddy water, less oxygen, algal blooms, and just damages to the aquatic life. The second issue that I address is the reduced groundwater recharge. And this sort of goes along with increased runoff means less water soaking into the ground. Right now, the water that hits the ground on Triple Springs Farm soaks slowly in through the soil, down into the groundwater, and recharges the springs that give Triple Springs Farm its name. And those springs feed the streams that flow on the site and then downstream of the site into ponds and other streams and all the way to Harrods Creek. When you have less flow in the springs, you're going to have less flow in the streams, and that means they'll be dried up at times. There'll be less water quality. There'll just be less aquatic life in them. The third issue is the on-site sewage disposal. We have 93 lots of 1 acre that will all be producing wastewater from the homes. That's something on the order of 40,000 gallons every day flowing into the subsurface. The big concern here is that the soil is overlaid on a karst geology. Karst means sinkholes, solution channels, fractures in the rock. That means that water will be less treated, potentially more contamination reaching the springs, which reaches the streams too. And so you'll have significant potential for contamination. I also believe because these lots are so small, given the topography and the development that's planned, it may be difficult to properly site and construct these septic tanks and leach fields on the site. So I want to thank you for your time.
Thank you, Mr. Wilson.
Next, I'd like to bring up David Surveys, CHMM-CPESC. He's an Environmental Compliance Manager with Patriot. Mr. Surveys has more than 40 years of experience. Mr. Surveys serves as a subject matter expert for environmental regulations and solid waste profiling. He is also an ISO 1400 lead auditor conducting air, water, environmental studies, obtaining air, NPDES and RECRA permits, preparing construction drawings for stormwater pollution prevention plans, providing construction services for stormwater. He has his MBA and a chemistry degree. He has certifications. He's a certified professional in erosion and sediment control, certified hazardous materials manager. He's also certified by the Institute of Hazardous Materials Management, accredited under ANSI, ISO, and IEC. He has many other certifications. He will be speaking and testifying as to evidence of waters located at the project and the capacity to address stormwater discharge and septic.
Good morning. My name is Dave Surveys. Address is 6150 East 75th Street, Indianapolis, Indiana, 46250. I'm here to speak about the review of the Pine Grove subdivision from pasture to residential impacts. The proposed subdivision, as we know, has been discussed previously, has 93 different lots, representing a major land use change. So these lots range anywhere from 1 to 5 acres, as noted, and each one will have its own opportunity for stormwater management and also its own septic management. So in my study, I talk about one of the easy equations, and I'll try not to go too far over the edge. Talking about what's called the rational equation. And what this does is looks at the stormwater, or excuse me, the rainwater intensity. And this is a factor that NOAA publishes, and it's a pinpoint accuracy on the property. It will tell you what the 24-hour and anywhere from a 2-year over 100 years. And it will tell you the rainfall event in that category. And typically we use anywhere from 2 to 10 to 100-year flood numbers in a 24-hour event. Also in there is what's called a runoff coefficient. This coefficient is in relationship to what the property's current condition is, which is, we consider that to be pasture, right? And then moving into a residential. So what these coefficients do is when you make that judgment, you're looking at what is the intended use of the property. So we deem this to be residential, right? Residential has a lot of what I'll call impervious surfaces. Does that make sense to everybody? Impervious versus pervious. So pervious means like grass, and impervious means your driveway, rooftop, pools, since we're in the south, any type of concrete surface that will sheet flow off the water. Intuitively, pasture land has what's called a lower coefficient, okay? Because of the impervious nature, and residential has a higher coefficient. So, for instance, the pasture land has a coefficient of 0.62, and that's all relationship to 1, okay? Whereas the residential coefficient is 0.75. So, as intuitively, that's a 21% increase in peak flow runoff, okay? The new development also would overload the existing stormwater drainage by a number of 14 times. So when you look at calculations of what your current stormwater infrastructure there is on Covered Bridge Road, excuse me if it's not a road, but that's what I recall, is a 24-inch concrete pipe, structural concrete pipe. And using what's called the Manning equation, which is in my document, you're looking at overflowing that by over 21%. Is the easy way to put that. So if you've ever seen a culvert overran, it usually erodes away. Also, the proposed stormwater basins may encroach on protected waterways. The blue stream, solid stream in the middle of the property that was shown is a Waters of the U.S. determination that will let the U.S. Army Corps adjudicate, but it is connected via a spring, a stream, two ponds, Harrods Creek, and the Ohio River. So that's where the jurisdiction will come into play. And obviously, I can't make that determination. That's what the Army Corps does. There's also 15 endangered species on the property that have been identified with the U.S. Fish and Wildlife. These include mussels, Indiana bats, where I'm from, insects, and plants. That's another impact that we need to explore. As reported earlier, there's a Jaeger house, but what wasn't pointed out was there's a cemetery on the site. I don't know if that's ever been discussed, but there is a cemetery that comes out of the woods and it has like a little ephemeral stream right beside it. Septic feasibility. As previously reported, there's 40 test holes that were dug. I don't know the condition of the 40 holes, but looking at USGS maps, which are in my report, you'll see that 91% of this soil is classified as somewhat limited, and that's due to the karst nature that Ward discussed, Mr. Wilson. My conclusions, basically stormwater impacts from the land use are significant, detrimental to adjacent and subdivision properties, and further ecological and archaeological assessments are required. I was not allowed on the property, like I said in my report, so I can't validate any of the articles that I found by research. That's all I have.
Thank you, Mr. Servies.
Last expert witness we're calling is Mark Fackler. He has a bachelor and master's studies of hydrology and groundwater geochemistry. Mr. Fackler has gained a wide range of environmental knowledge and work experience while performing various environmental duties for General Electric Company and the private consulting industry. Mr. Fackler has over 30 years of extensive experience in various environmental areas such as chemical management, minimization of environmental liabilities, and many other things. He has conducted thousands of environmental due diligence studies of commercial real estate and has acted as the primary investigator on extensive remediation sites and has been involved in the development and implementation of remediation procedures at numerous locations. He has worked directly with developers. Mr. Fackler provided educational outreach and training environmental risk management to many. He will speak on the structural and environmental risks associated with the presence of active karst and perched groundwater discharging in multiple springs and certain chemicals that will be discharged from these homes and the remediation potential or inability to remediate some of those contaminants and the adverse impact of stormwater and groundwater flow in an area of sensitive receptors due to the topography and the geology of the site.
May I get the overhead? Does that work?
Yes, sir.
Sorry. I don't know the protocol. Thank you. Mark Fackler. My address is 10310 Cover Bridge Road in Prospect. And what I want to discuss here is that, which direction? Sorry. And this is in the karst geology and environmental assessment report that I prepared. The proposed development, as expressed by the counsel for the developer, doesn't take into account the complexity of the property that we're dealing with here. They're doing a two-dimensional analysis. They're saying, hey, the regs say it's fine, it's zoned this, but I'm asking you all to look under the surface because that is why this property is unique. It's in a designated intense karst area. As noted above, the karst area has sinks, it has solution cavities, which provide direct conduits for the water going through it. The upper part of the Louisville limestone is notorious for this, and we see sinkholes all around not only this area, the county, but also on the property as well as the adjoining properties. This is still an active karst system, as demonstrated in these aerials. This is a property on Constantine, which backs up to lots 19 and 20 on the proposed development. This is a 1998 aerial photograph, and as you can see, there is nothing there in the field. Fast forward, you see the sinkhole that is there today. So this is not an inactive karst system. There's still, just because there's not a sinkhole doesn't mean there isn't a solution cavity below it that can open up, especially when we change the hydrology of the area. So let's talk about the name of the LLC, Triple Springs. I mean, we're talking about springs. They talk about the adjoining properties or adjoining developments of Constantine and Overlook and Neville Mead. What those don't have, they don't have the springs. They don't have springs that discharge to a conservation easement. We have to look at this in 3 dimensions, and that's why you're all here. Otherwise, it's just, as they argue, an administrative function, and I question that. They're talking about, I mean, think about it, folks. They're talking about developing 93 homes on a property, an LLC named after Triple Springs. Those are large luxury homes. They're all going to be on septic. And because, as they noted before, due to the compaction of the soil, anybody that's dug a basement and that soil, that clay has been dug around, you have to bring in topsoil because you can't even get grass to grow in it. It's so impermeable. So we're going to reduce the natural infiltration of clean rainwater, and we're going to substitute it for septic effluent, wastewater, contaminated sewage. Now, the scale of this is quite significant. So let's talk about those systems. So you have your septic system, which discharges to a clarifying box. That wastewater then goes to the leach field, which directly soaks into the ground. Now, Mr. Ward, I'm sure, will do a great job at making sure that those are cited for biological remediation, making sure that the biological wastes are eaten up by the bacteria. But what about the chemicals? The chemicals are not degraded by those bacteria. As you see in that diagram, they will soak through, and because of the karst, they could go into a shallow aquifer and a direct conduit like a pipeline. Now, we know that there's shallow water because we've got Triple Springs on the property. And think about what goes into your sinks, your toilets, all of the household chemicals, medications, pharmaceuticals, hormones, testosterone supplements, hazardous materials that you just dump down the sink, shops. People are probably going to have garages and shops. None of these are going to be remediated by those biological contaminants or bacteria. So let's talk about the sheer quantity, okay? One of the problems with groundwater is you can't see it, okay? So I'm going to help you visualize what we're talking about here. Now we're talking 93 homes, 400 or so gallons per day, if not more. These are going to have multiple bathrooms, dishwashers, everything. So we're talking about 40,000 gallons a day, almost over 15 million gallons of water a year of contaminated septic effluent is going to be discharged to the ground. Now, to help visualize that, I have superimposed to scale a 2 million gallon above ground storage tank. Now, That's what it looks like on the inside. There will be the equivalent of 7 of these discharging to this property every year. That is a lot of sewage going into the ground. Now, will the leach field and the bacteria get it all? I would argue no. They argue there's not going to be an environmental impact under the comprehensive plan. I would argue, how do they make that assessment? They didn't come up with any discussion. That is 90,000 gallons per acre, or the equivalent of 5 15 by 32 swimming pools per acre that is going to be discharged to this. So let's talk about not only are we going to reduce the water infiltration, but we're going to substitute that for contaminated effluent. And some of those, there was a recent 2024 study of forever chemicals that there is no ability to break down, that shows elevated forever chemicals being discharged from residential septic, and that's in that report. I'm not going to go into it. And the cleanup level is exponentially higher than the vinyl chloride that they evacuated East Palestine, Ohio for. Okay? So I'm going to close this because we're running out of time. The complexity of the physical nature of this property and the sensitive receptors require you all to take a deeper look at this. This isn't just an administrative action, okay? You all are in charge of not leaving a regretful legacy from this development. This property isn't like those other 4 developments. Please take a look at the reports, and I ask you all to turn this down. Thank you.
Thank you.
If I could, Stephen House.
Are those materials presented within what has been given to the commissioners?
Yes, they are all in my report.
Thank you. All right,
If I
sorry to
could,
interrupt. Please go.
No problem. I'm just trying to be brief as possible in light of time, and we would ask, in light of all of the opposition, we might be granted a little leniency on that. But if,
The commission will decide on that.
sure, of
okay?
course, that's why I just made the request. Could Riverfields, and I'm sorry, I've lost track of everybody. If Chris, yes, thank you.
Dr. Kristen Forrest, President and CEO, Riverfields, 1907 Deerwood Avenue, Louisville, 40205.
Thank you.
So thank you for having us here. Thank you for hearing us out. I think my colleagues have done an excellent job outlining the scientific foundations for why we oppose this development. I would like to talk a little bit about it from the Riverfields perspective. We are a 66-year-old advocacy and conservation organization. I'm very proud to lead an organization that stewards and protects 2,300 acres of conservation easements in 3 counties. I'd like to talk for a moment about what it means to be a steward. It means being part of something that was there before you and that will be greater for your having been there and that will outlast you. That's what we stand for at this organization. Mr. and Mrs. Brown, whose farm we hold the conservation easement to, have been excellent stewards for well over a quarter of a century, and we worry that this development will jeopardize that beautiful relationship we have enjoyed with these wonderful stewards of the land for decades. We see this development as a threat to the health of the land and water on one of our oldest conservation easements, comprising 108 acres in the Harrods Creek watershed. This land is a buffer protecting our common waterways. It is highly vulnerable, and we should treat it as such. An easement like this held by Mr. and Mrs. Brown brings tremendous community benefit. Even if it's not publicly accessible, it is providing buffering and protection for all of us. It protects ecological and scenic values, and it comes with, as a conservation easement does, significant economic sacrifice for the owner. This is a permanent commitment. It also comes with significant legal consequences if the terms of the easement are violated, even if that comes from a third party. We believe that the conservation values of Beechwood Farm are multiple: historic, cultural, riparian forest, waterway, agricultural land, open space, and scenic views, if they are lost, if they are jeopardized by development on a neighboring property, which all the evidence shows that they will be, they are lost forever. You as a governing body are choosing between two precedents: the healthy precedent of a conservation easement and the unhealthy precedent of a development on land this vulnerable and fragile adjacent to a conservation easement. These two precedents cannot live happily in the same place. In the interest of conservation, stewardship, and the right of a property owner to control the fate of their own land that they have committed to steward, I ask you to reject this proposal. Thank you.
Thank you.
Just trying to keep this moving along. Stephen Houston again. Ms. Brown, would you like to speak?
Hello, I'm Sue Brown. My husband and Hewitt and I live at 10431 Coverbridge Road. We own 170 acres, which we bought about 57 years ago. Our property shares a property line with the proposed development. In 1991, as you've heard, we decided we wanted to save at least half of our property from being developed, and we made half of it a conservation easement, in which in our case means only 2 houses can be built on it. The rest must be used for agriculture. We have a pond which fronts on this part of the property, which is filled by a spring, which comes from the Triple Springs property. The developers are proposing to have a retention basin made over the spring, and the retention basin is not large enough, perhaps as large as a lake, to hold all the hundreds of thousands of gallons of water that you have heard Mark Fackler describe. It will wash away our pond and deposit many pollutants, and when it rains, it will turn into a mini sewer. This will make it untenable for our property. This will damage the area that was deemed valuable enough for a conservation easement. In addition, I am concerned about the road. Coverbridge Road is a 2-lane state highway with no shoulders. There have been at least 3 fatal accidents in front of our driveway on Coverbridge Road, and many other non-fatal. Every time also, there's an accident on I-71, and considering a new development is close by as well, the traffic is rerouted to Coverbridge Road. Now, picture this. If there were to be 90 houses constructed on this property, imagine the number of construction vehicles, bulldozers, concrete mixers, contractors' trucks that will be coming down the road at the same time. After construction, there will be service vehicles like landscape contractors with their trailers, school buses, etc., in addition to the ordinary people living in those houses. In my mind, and hopefully in your mind, you will realize that this will change the entire character of this part of Oldham County. Are you sure you want to have this happen?
Hi, my name's Kim Smith, 11308 Spring Hollow Court, Prospect, Kentucky. I'm here to oppose the current Pine Grove's Triple Springs proposal. And I am the founder of a national program, a not-for-profit. It's called Second Stride. So we founded this program directly on Sue Brown, the Brown's Farm, so in Oldham County. Oldham County proud, developed program, very supported in the community. We transition so far about 1,900 horses through our program. We're averaging almost 200 a year, and it's growing. We service the horses directly out of the local racetracks like Churchill Downs and the surrounding areas. All the top trainers use us. Due to a lack of land through land development, we are finding it harder and harder to expand our program. So obviously, this relates to our use of this land that we've been at since 1999. Also in the middle, the spring, one of the springs from Triple Springs, feeds over probably about a third of our horses' water through 365 days a year. So I'm very concerned about what might happen to that spring and the lack of acreage that we would have available if that spring failed us, or became contaminated. It would greatly harm our program and the amount of horses we can service our community. And if I look through this room and can see the people here, if everyone can stand that knows Second Stride, has any involvement with Second Stride, is employed by Second Stride, has gotten horses from Second Stride, knows of us, comes to our educational programs, which we have funded through grants that we've received through the Oldham County Community Foundation. So I just want to let you know that it's a big program, it's community proud, and we are so proud of the heritage of Oldham County and the agriculture part through the tourism that's provided in Oldham County, and that's why we're here. And that's what makes it so special. And this isn't cookie cutter land. I would invite all of you to come out to Second Stride, do a tour, see the land for yourself, and decide. Just last week, I know there's people in this room that can testify. We had to, I see two of them here, we had to call Sue Brown and her farm staff and have them fill in a hole that is in our horse field that just popped up overnight. So it's in a field directly adjacent to this land. So I know it's active. We have to fill the holes several times a year, and they're deep enough to break a leg, so even yours. So you have to be careful where you're walking when you're in the field. So just I'd like for you to consider that this isn't just a cookie cutter block of land. Come out, see it, be involved, and it's going to take discernment to make a good choice here that will benefit your community. Thank you.
Thank you.
Ms. Hartung?
Good morning. I'm Barbara Hartung. I live at 10,310 Covered Bridge Road. About 40 years ago, I moved to the Covered Bridge area, and it's sort of coming home. My great-grandmother and her parents are buried in Brownsboro. It's sort of a family thing. I love this area. And I see changes, and I see changes that come slowly, and then I see this proposed change. And I wondered, what do you all have to look at when you decide whether it's appropriate? Well, we've already talked about the subdivision regulations. We've talked about the comprehensive plan. What we have not talked about is the unique Brownsboro master plan, which governs this area. Now, according to the subdivision regulations themselves, they are to be guided by the comprehensive plan. The comprehensive plan, as adopted in 2020 and enacted by ordinance, includes the master plan for the Brownsboro area. For purposes of today's hearing, the most important areas of the regulations that relate to the plans are those that say it will protect the character of Oldham County, it will prevent overcrowding of the land, it will provide for adequate drainage, it will minimize pollutions of streams and ponds, it will preserve natural features, and it will encourage the wise use and management of natural resources. I would posit that this proposal does not do that. When reviewing the proposal, you have to find that it's suitable for its surroundings. You have to find it's environmentally acceptable, and that means that it's non-polluting. And I would point out, while we've been told that this is a ministerial and not purely ministerial, and not something that you have any discretion on, that is not accurate. Because if any questions remain concerning the impact upon the environment, the proposed development should not be approved at this time. The regulations also state that if there are any more stringent requirements in any other rule adopted by Oldham County than are found in the regulations, those more stringent rules have to be applied. So let's look at those. What does the Brownsboro Master Plan say? The corridor, as recognized in that plan, is characterized by large farms like Fox Hollow, riding academies and stables like Second Stride, Spring Run Farms, Aspiring Heights, and it also includes the Bata Trail. These are all items that the tourist departments of Oldham County look at and go, this is great, and they advertise. Triple Springs Farm is centered among all of these, in addition to the subdivisions that were mentioned that we'll talk about in a minute. When the master plan for Brownsboro was adopted, The Oldham era noted, and that was in 2009, the plan includes incentives to developers to build a subdivision with landscape buffers, open space, and walking or horse or even bicycle paths. The plan also says that high-density development needs to be limited to the town of Brownsboro and to the area around Norton Commons, because the Brownsboro area extends that far. It goes to the Jefferson County line. The proposed development doesn't meet these standards, but it also doesn't meet some of the other items. Community character, seeking to preserve historic and rural identity by identifying and protecting historic sites and protecting the scenic corridor. Now, we've already talked about the Jaeger House and the slave quarters, but the minutes of the meeting with the developers that was held in December, questions were asked about what was going to be done with that Jaeger House, and the answer was, we're going to sell it to someone. The next question was, what happens if that person doesn't want to preserve it? And the minutes reflect that whatever that answer was, it wasn't recorded. Environmental section of the master plan seeks to protect natural resources, farmland, and Harrods Creek watershed from inappropriate development by encouraging low-impact development techniques. We've already heard about the karst features, the sinkholes, the springs, the drainage directly into Harrods Creek, the millions of gallons of septic waste. The plan before the committee is clearly inappropriate under this standard. The land use standard of the master plan seeks to enhance the rural and historic character by assuring future land uses are compatible in scale, character, and form with existing developments. It also encourages the creation of conservation and open space areas. I believe that proposed development completely fails to meet these standards. Let's talk about the developments along Covered Bridge. None of them are as large as this property in terms of the number of houses. But the one that is and none of them have lots that are as small. There may be one, there may be two. I lived on Constantine for 30 years. There's one lot that's less than 3 acres, one lot. Can this be turned on? How do I do that? Oh, okay. We talked about Hidden Springs. And what wasn't mentioned about Hidden Springs, it is 1 acre lots for the most part. It's, as you can see, quite far back from Covered Bridge, but it also has 52 acres of green space that belongs to the association. That's more than 50% of the entire land that subdivision lies on. If we were to apply the same standard here, 75 acres would need to be dedicated to green space. And the comprehensive plan contemplates that there will be open spaces in subdivisions. Comprehensive plan says you need these, and then it goes on in item 2 and it says, the ownership and management of open space created through the development process needs to be set forth in a management plan, and that needs to be approved as part of the development application. But the minutes from the meeting that the developer held with us said, the proposed net density, it goes on and on and on, it says the open space concept is larger lots. That's not open space. This does not meet the open space requirement. Now, the other subdivisions along the Brownsboro Road, Constantine, Neville Mead, Overlook, and Covered Bridge, they're all substantially smaller, maybe 30 houses, maybe not quite that many. The other thing I wanted to talk about, because I had put this in my study, is the traffic plan. I don't think the traffic analysis is adequate to explain what's going to happen to Covered Bridge Road. As I understand the term level of service, master plan again says, when you're developing in this area, You have to create a safe transportation network for all modes of transportation, including bikes. Part of Covered Bridge Road is designated a shared road. It's not the part that is right in front of Triple Springs. And if my presentation that is on paper for you seems to say that, that's not what I meant to say. It's a bit down the road. But as you can see from this map, the 329 shared road, which runs from 1694 down Covered Bridge, then to 1694 again, is often used by many of the bicycling groups in town. They put it on the internet, and one of the best that they suggest is, rather than going out to Goshen and getting on 1694 there, come out to Prospect, go on 42 and come up 329 past Triple Springs, all the way around, and then 1694 back into the county. Anybody who's lived on Covered Bridge for any length of time knows there are days when there may be 25, 30, 40 bicyclists. They may come in pods, they may come 2, 3 at a time. It might take you 5, 10 minutes longer to get past them on a really busy day. I do not think the travel study took that into account. We've also heard about the narrowness of the road. You can't pass a bicycle if there's a car coming another way. So let's put 900 or more cars a day additionally on the road and see how long it takes when the bicyclists are also using this. Finally, I would like to point out that the updated comprehensive plan includes a vision statement, and it says, "The people of Oldham County are connected through the preservation and promotion of historic areas along safe transportation corridors. Oldham County has preserved its rural character and natural environment by maintaining vistas and green spaces. Our leadership respects and adheres to the values of the community, and our leadership has the political will to implement these values." The Planning and Development website also contains a statement that its offices reviews development proposals for compliance with locally adopted plans and regulations. I think it's crystal clear that the proposed development does not satisfy the Brownsboro Master Plan, does not satisfy many aspects of the comprehensive plan, and therefore should not be approved under the subdivision regulations, which look to those for guidance. So, consistent with the commitment of the Planning and Development Services Office and the comprehensive plan's vision statement, we ask this committee to show it has the political will to protect Triple Spring Farms environment from harm as required by the subdivision regulations, and to implement the values shown by the comprehensive plan and the Brownsboro Master Plan, and reject the development proposal for Triple Springs. Thank you.
If I could, I would like to ask the commission for a little leniency. I promise I've cut a big chunk of my presentation, and I will be brief.
Commissioners, anyone wish to move for additional time for opposition?
Mr. Chairman,
Yes.
can we ask Mr. Houston or the lady who just spoke, do we have copies of those documents that she just presented? I didn't
Yes,
see
you
them.
do. Everything was filed on time
Was
and
it?
presented.
Thank you.
Don't have copies of those.
It was my
So
understanding
she
that we
would
did.
present those to us.
You have a copy of
Those
the
are
report.
items we need for evidence. Just, if you will, submit those, okay?
My apologies. I thought it was attached.
Mhm.
We were told that they would make copies of everything that they submitted yesterday because they submitted about 1,000 pages of documents yesterday. This is 600 single-sided pages, and then we received basically everything that was in front of you. We just saved that to the file. We received it at 4 p.m. or right before 4 p.m. yesterday.
All right,
So we did
so-
not have a chance to review any of it because it was submitted
Items
yesterday.
referenced in testimony,
Mhm.
we need submitted for evidence for the
Yeah,
record
and
of the
I
hearing.
have that for Ms.
Okay?
Edgar.
All right.
That I'll give it to her.
All right, commissioners, back
Mr.
to the
Chairman.
question. Yes, sir.
Before we go to that, can we take a 10-minute recess? real
Yeah,
quick,
that's a
please?
great idea. Let's do that.
Thank you,
10.
sir.
All right, thank you, everyone. We'll come back to order at this time. Sir, did you have something to share with us?
Yes, first, I just wanted to know the commission's ruling on my request for leniency for a short bit of time.
I'm moving in that direction now. Anything
Sorry.
else?
I have a presentation to make.
Commissioners, do you wish to extend additional time for presentation of opposition? Mr. Douglas.
How long do you think you need?
I have cut out the majority of my presentation. I will take less than 5 minutes.
We give him, if the commission wishes, we'll give them 8 minutes.
Is that a motion, sir?
That's a motion.
All right, so understand, if we extend 8 to opposition testimony, we are also extending 8 to applicant.
Correct.
Okay, everybody clear on this? All right. Do I have a second? Mr. Hampton, Ms. Davis, thank you. All right, and we will do this by voice vote. All in favor, please signify by saying aye. Opposed, like sign. All right, we'll go with 8 minutes. Let's get that clock reset. Floor is yours.
Thank you, and thanks for the consideration, commission members. You've heard from hundreds of neighbors in writing. You've heard from several today. There was a reference to us filing a lot of documents. I just want the commission to know the great bulk of those were letters that are submitted by neighbors in opposition to this. And we are not asking you to review all of them, but we thought it was important to show you how important this is to the community. You've heard from not one or two, but 4 experts today, not just statements from us, but 4 experts today, including Riverfields, about the damage this application, this development would do in this location at the size it's being proposed. We are not here today to argue that the development should not occur in Oldham County. I mean, that development should not occur in Oldham County. We know that development is going to happen. We're not saying that all development should be stopped. But the comp plan, the comprehensive plan, and I'll say comp plan for brevity moving forward, the comprehensive plan is something you are required to follow. When the applicant referenced in their presentation all of the minimum requirements, they failed to recognize the requirements set forth in the comprehensive plan. Those are requirements that also control your decisions, and you have the discretion to decide whether or not this meets the comprehensive plan. Just because it meets the bare minimum of what they believe is required in the application does not control your ability to turn this down if you don't believe this development should happen in this precise location, the way they've applied it, the way they've applied for 93 houses at this specific location. That is within your discretion. As I said before, as you heard from testimony, this is rural. This is farmland. This is farmland that's actually being farmed. I know a lot of land that people live on are not being farmed. This is land that you've heard from testimony from some of the neighbors, but there are plenty more that we didn't have a chance to get to who actually farm land right in this area. If approved, this will change the environment of this area and the character of it, which is something you're required to consider. Applications for development can be approved if appropriate and in the right areas. You're allowed to consider not only whether this application fits the bare minimum of the application rules, but whether or not it complies with the comprehensive plan at this location and at the size they are proposing. The few subdivisions that they cited, you've already heard. They are much smaller with larger lots, and they do not run the majority length of a farm that's in a conservation easement. Sue and Hewitt Brown already did their part, selflessly donating their land into a conservation easement that's going to be preserved for generations and generations to come, in fact, perpetuity. Riverfields has agreed to accept that into their program because of the location and existence of the properties, including waters and the land itself. As they referenced, this acts as a buffer for the waterways, for other land nearby. Riverfields chose this property for a reason and because of its importance to Oldham County. And as you heard from them, this will significantly hurt that conservation easement. I do want to highlight that the comprehensive plan and subdivision regulations make clear that you're to encourage conservation easements, not deter them. You're to encourage conservation easements in Oldham County and appreciate them and help protect them, not harm them. That is a part of the rules that opposing counsel referenced as ministerial, but weren't referenced in the application or their presentation. My apologies, bear with me. I am attempting to work with the time at hand. When it comes to the historic building, there were questions raised at the TRC hearings. And at the time, the developer seemed confused by that and off the cuff said that, well, he's probably just going to sell them to somebody else and they can do whatever they want. Now we're hearing a different story. Now what he said is that he has every intention, which is not binding, to preserve them if practical. I mean, if you can just get with the idea that that has zero enforcement whatsoever, it's something they're just ignoring and asking you to ignore it as well. Furthermore, when the Army Corps looks at this under a 404, they also look at historic issues, not just the waterways. As far as traffic impacts, common sense tells you that covered bridge and other nearby roads are a problem. I won't go through all the problems because I believe you've heard most of them. I did want to mention one. Several inches of water, if you drive this at all during rain times, several inches of water flow over top of this road. That creates a severely dangerous condition and leads to accidents. As you heard earlier, there have been multiple fatalities. That waterway makes this condition inappropriate. The impact study cited by the applicant does not take that into consideration. It also doesn't take into consideration that this is designated as a shared roadway with bikes. And on any given weekend, you will find herds of bikes traveling down this road. And that's already allowed. That's a legal thing. Adding to this will simply exacerbate those problems and create more accidents, something we don't want to see happen. And it was not referenced, even though it's required for you to consider all of the aspects and the existing issues. Even if you believe the developer when he says he satisfied the bare minimum requirements, and that doesn't matter. Bare minimum is not what you're required to do. You wouldn't be here if all they have to do is check boxes. You're here to enforce the comprehensive plan and the planned growth that was thoughtfully considered and designated during the considerations and preparation of that comprehensive plan. We know your job is difficult. It requires tough decisions a lot of the times. This is not one of them. This clearly violates the comprehensive plan. We filed multiple documents citing to the comprehensive plan specifically. We won't have time to get to them right now for purposes of this record, but it violates the comprehensive plan in a lot of ways. This is not appropriate at this location. We ask that you deny it. The case cited by opposing counsel Snyder only says that you should approve a proposal if it meets all requirements. He failed to mention that the comprehensive plan is one of those requirements. With that, I would like to turn over and leave 30 seconds to one other presenter that's valuable.
Thanks. All right. Don Langen, 3901 Eagle Way, Prospect. I'm a developer. I've developed numerous properties in Jefferson County and 2 on Covered Bridge Road. One being the Boy Scout camp, about 105 acres.
Spence, to your points here, we are out of time.
Can't say a thing?
Finish, please.
105 acres. We put 22 houses on it, gave 60 acres to conservancy, walking paths, green spaces, etc. This is a raping of the land, asking for that number of properties on that property. Thank you.
Thank you. All right, Mr. Swansburg.
fine, Steve. No, you're fine. All right, Mr. Chairman, members of the commission, ladies and gentlemen out here in the public, anybody watching as well. So I've got, is this 8 minutes, Mr. Chairman, in terms of additional presentation, or 8 minutes for rebuttal purposes? I apologize.
You have, this is applications,
Support.
testimony, and evidence from you.
Okay.
Applicant's testimony and evidence.
Okay. I've also got rebuttal purposes, which I will talk about for purposes of just adding additional information for you all. One of the things that I did not actually get to talk about in the presentation, and that is on me for not putting in there, but it has been raised in some way, is transportation. And one of the things I did want to make sure was put into the record is that right now there is a communication waiting from the Kentucky Transportation Cabinet about this particular project. It's been referenced by Mr. Silliman that we have not received a communication back from them. What I'm going to represent to you all and to everybody here is that Triple Springs Partners LLC will comply with the final recommendation of the Kentucky Transportation Cabinet as it relates to the entrance and the roadway adjacent to this property. So if whatever the Transportation Cabinet finally recommends, Triple Springs is going to adhere to that recommendation. So I want to make sure that that is stated on the record in terms of our position. There's a whole lot of information here for terms of rebuttal purposes, Mr. Chairman. In terms of support, of course, if I can't, Mr. Silliman, will you just come up for a second? I don't mean to put you on the spot, I promise. I'm going to make it a real straightforward question. So, Mr. Silliman, you're the county engineer, is that right?
That's correct.
And that you've received the application in support of this proposal, is that correct?
I received the application, yes.
Okay, and you had an opportunity to review that application, right?
That's correct.
Okay, and is it your opinion as a county engineer that the application meets the requirements set forth either in the subdivision regulations in terms of what is required for this body to approve that particular application?
Yes, understanding that other regulations would be adhered to during construction plan review.
So would just make sure I understand as well, there would actually be a second component to before a house is actually built in terms of what would be required in terms of permitting or analysis of the property. Is that right?
That's correct.
Okay. And that process occurs, assuming an approval, that would occur after an approval by this body of the preliminary plat. Is that correct?
That's correct.
Okay. Thank you, Mr. Silliman. I appreciate that. Oh, actually, let me just ask you a couple more. I apologize. I got 5 minutes, so I might as well take the time. In terms of, let's just talk about a couple of specifics here real quick. Stormwater runoff. To the best of your knowledge, does the proposal submitted by the applicant meet the requirements presently for Oldham County's stormwater retention ordinance?
It doesn't, but it will be analyzed and designed at a future time, and it will be held to those ordinances.
Okay. Yeah. And that would be a process that would occur, assuming it's approval, there would be a process that would occur as part of that construction permitting process that we just talked about. Is that right?
That's correct.
Okay. I think that's all I'm going to bug you about right now. Thank you. There was one area that I wanted to make sure that I talked about here just for the purpose of discussing this. And again, this is maybe some rebuttal, Mr. Chairman. Please keep me in line if this is borderline rebuttal. But just for purposes, someone mentioned something about a cemetery on the property, which obviously would be a requirement to put on the development plan. The cemetery is actually not on the property. There is a cemetery. There's a cemetery north of the property. That's absolutely correct. But it is not actually on the property that is actually part of this development. And so it's actually separate and apart from what we are proposing at this point. To the extent that it would be on the property, if it were, we would obviously put that on there, and certainly there would be some regulations that would be followed to that extent. But that is not actually part of this particular property. I just want to make sure that that's noted for anyone who is concerned about that issue. Again, I'll just reiterate for purposes of testimony, that, again, the county health department went out to the site And as you can see on the screen, Charlie Ward, on behalf of the health department, conducted an on-site soil evaluation of the subdivision. He went out, he dug 40 holes consistent with the subdivision regulations, and again found it, quote, entirely provisionally suitable for subdivision development. That is the requirement under subdivision regulation 7A. I want to make sure that I put that into the record again. And as we mentioned before, this project again includes and contemplates, as Mr. Silman just talked about, contemplates that there are drainage and detention basins within the plan, and assuming approval by this body will be more thoroughly looked at as part of the permitting process, particularly during construction and excavation, assuming approval. That will all be again considered and adhered to by the applicant when the time comes for them to build the subdivision, assuming approval. So I want to make sure, again, we just reiterate that point. Mr. Chairman, in purposes of actually just presenting new information, I've got a whole lot in terms of rebuttal. I'm not going to present anything new at this point. I do want to address a number of issues that were presented before in terms of rebuttal. My understanding is that would occur at a different point rather than complicating the matter. I'm going to yield back at this point, but I will be back for purposes of rebuttal and addressing a number of concerns that were raised in the opposition's presentation.
Thank you, Mr. Swansburg. All right. Next item up is questions from the commission of those providing testimony or opposing testimony. So commissioners, who would like to go first? This is for anybody who has provided testimony.
Mr. Chairman. Mr. Swansburg, please.
Hang on, I've got Barry first, okay?
Oh, I'm sorry. Yep.
Thank you, Mr. Chairman. Yes. Two things. Number one, for everybody's edification, would you explain infill?
So infill, the way I understand it, and I'll go ahead and pull the slide back up when we talk about it. Infill, the way that the, here we go. So infill development. So the comprehensive plan talks specifically about infill development. The idea that what you're actually trying to avoid, as I mentioned before, is this whole notion of leapfrogging when you've got developments. You've got a proposal that sits right here, for example, then you got a bunch of open space, then you got a proposal that sits right here, and then a bunch of open space, and then you got a proposal that sits over there. The problem with that, of course, being that the county, for example, would have to spend an exorbitant amount of money and effort in order to get the services provided there, whether, for example, it might be water, whether it might be fire, for example, in terms of having those resources used. The idea is that you actually try to fill in areas where you can essentially duplicate services to minimize that cost. So for example, on the screen, well, again, we're proposing in this sense, again, page 51 of the comprehensive plan talks about was utilizing existing service infrastructure and lessening economic costs of expanding things like utility lines, for example, power lines, gas lines, water lines, whatever that might be. For example, you want to put it in an area where you're reducing the cost and burden on the county when a development is coming in place. So ideally, you would put a new development in an area that is adjacent to other developments so you can duplicate or continue on that existing service infrastructure. Does that answer your question?
Yes, thank you. I've got one more.
Yes, sir.
There seems to be a little confusion on the Jaeger house. I know I think it's on lot 76. I could be wrong about that, but that's not my point. My point is you use the term, I think, for future use at least 3 times. And I don't think anything's really clear about what that means.
Okay.
And I think it came up in the opposition, and I just wanted to give you a chance to put a concrete, if you would, answer as to what that means.
Do y'all want to talk about that? Do you want to talk about it, or you want me to talk about it? What's that? Do you want to talk about it? Or you want me to?
Well, we have
Hang on. Get your name and address for the record, please.
Robert Jones, 3215 Highway 1694, Crestwood, Kentucky. Your question was, what do we intend to do with the...
It's not what you intend to do. It's what's really going to happen to the Jaeger property instead of just using the term
Well, I have a
future
bunch of
use.
slides here I'd like to show you. Did you bring that up?
Go to the overhead.
Yes. This, this was a slide from 1982 showing the house and the slave cabins. If you go over there today, you would find that the slave cabins, roofs and everything has totally fallen in. This is what we found when we bought the property. It was not taken care of, even though some people say it was. That's the condition we found the property when we purchased it. Now I'd like to show you what it looks like today. That was after we started cleaning it up and trying to make it look like a piece of property that could be developed into a very nice home. And I hope that answers your questions for it. But let me take it a step further. My wife's great aunt was married to Yeager. So we have some family interest in preserving this home also.
All right, Mr. Hampton, anything additional?
Well, yes.
Continue.
I appreciate what Mr. Jones had to say, but I want to hear from council if he could explain in more concrete terms what future use means. Are they going to sell it to somebody for residence? Is it going to be kept up as a historic property? I still don't really see that it's been answered. Sorry.
Sure. I understand what you're saying. So as you can see on the lot there, it's actually an existing on lot 78, 2.8 acres. So it's contemplated as existing as part of this development. So there's no plan to get rid of the house at this point, right? So again, it's existing house, it's on there at this point. Ideally speaking, somebody would ultimately be able to take this house and make it the great house that it was in the 1850s, whether that turns out to be the developer, whether that turns out to be someone who buys a property, whoever that might be. The unfortunate part is we're not entirely sure who it might be. Somebody may be able to do that. We want to preserve it, though, for the possibility that somebody can actually make this house, if possible, the house that was as great as it was back in the 1850s, and quite frankly, as nice as the area was back in 1982 before it became overgrown.
I appreciate that. Can Mr. Jones guarantee that it won't be torn down?
We, in the contract with the original owner, said that we would preserve it, sell it, but we would not tear it down.
Thank you.
All right, Mr. Hampton, you good?
I am.
Thank you.
Thank you, Mr. Chairman.
Mr. Marsh.
Mr. Swansburg.
Yes, sir.
Clarification.
Yes, sir.
When I look at the parcel 10-00-00-4, it comes up as a 260-acre parcel, and we're talking about 153 acres here, and it says the development plan is 93 acres. The residual isn't listed as another lot. How do the acres all come together?
Well, in terms of the 156 versus 93 versus 200.
260
So,
lots. Is that
developer may be able to better
where you
answer
drew the
this.
line? Is the part above considered a lot? I guess is my question.
No.
I don't see a designation.
No. I'm sorry. No. For purposes of answering, I can answer that question. The developer may be able to answer like the logistics behind 156 versus 90, how that line might have been drawn. But I can answer for purposes that this is not a lot within the proposed subdivision. This is actually owned by a separate LLC.
Okay.
So the 93 lots that we're talking about are all south of that crudely drawn blue line.
So all the testimony we've heard is only regarding below
Yes,
that?
the proposal only contemplates what is south of this blue line. That is the actual plan before you.
Okay.
There is no plan before you that talks about this property in any way, shape, or form. This is a separate property. It's not a lot within the development plan. Does that answer your question?
Anna might have some more
Sure.
information for me there.
I'll be as quick as possible. Anna Barge again. So, I think, nope, that's not mine. So in my site history, I said there was a minor plat. Let's see, I'm trying to find where my presentation. Oh, I already passed it. There is a minor plat in 2024 to create that 156.4 acre parcel that's considered today. If you're looking at our GIS, sometimes there's delayed times between our GIS being updated from the PVA's website and when that minor plat was created. Does that answer your question? And it's 93 lots on 156.4 acres. That's where the 93 is confusing.
The 93 there, I was thinking of as the whole thing, it would be 94, there would be a residual that larger, but that is not the case. There is a minor plat drawn through there.
Of that 200 something acres that it originally was, there is a minor plat of 156 for that lower section that's being considered today.
Thand you. That
All right.
answers the question.
Figured I could
Good,
let
Mr.
that.
Marsh?
Yes, thank
Okay,
you.
questions, commissioners? Ms. Jones?
Okay, this is for Mr. Swansburg also. They were asking, is there, or somebody mentioned that there's like no open space, that's all included in the lots. Is there any open space?
Open space in the context of designated open space?
Yes.
To the best of my knowledge, there's actually not designated open space per se. The idea is that we've got 1 acre lots with homes on them, for example, which I know I'm hearing a lot of snickering, but as a practical matter, Ms. Jones, the idea is that you're taking 156 acres, you're putting 93 lots, so you've got a low density development. Again, I use that term in a colloquial sense, in a sense for the common understanding, as opposed to a definition. Although I would argue it's also low density from a legal perspective as well. But the idea being that you're going to put homes on 1 acre lots, so you're not going to have a Norton Commons style development, for example, or a high intense, or even, for example, a Glen Oaks development where they're sitting on less than 1 acre. You're actually sitting on more expansive. So the idea really is that there isn't necessarily defined open space per se, but the idea is that the lots were going to be large enough so that the homes weren't going to overpower the whole subdivision. Again, that is the plan that is put forward. Does that answer your question?
Yes, so that northern part, I think as you kind of answered that question, that's not considered open space because it's not part of this.
That's correct.
At all. Okay.
Yes.
Okay.
All right.
And I had a couple more questions.
Continue.
For Mr. Fackler.
Yes, ma'am.
And you said that there's no springs in surrounding properties. So there are, like, I think you said 3 springs on this property. And is that all in the part that they are developing? I mean, do you know the specific location of those springs?
So there are currently 2 within the development that are feeding the blue line streams. The one going south towards 329, the other going to the west. Now, I have not been allowed to go onto the property. Those are flowing. The neighbors have testified that they flow all the time into her pond. The aerial photos, I have aerial photos going back to 1949 that show that stream going over both of those streams. And, you know, they're, because of the karst topography that's there.
Okay, and you stated that there are no springs in surrounding properties, so the only springs in this area are located in this development area?
Well, I mean, they were talking about the other properties, and there were no mapped springs on any of those developments that I could find online. Obviously, I haven't walked every square foot of the Overlook and Neville Mead, but, you know, they call this Triple Springs for a reason.
Okay.
You know, and the argument is, you know, Section 5.9 of the subdivision rules state that if there's potential for environmental impacts, that it shouldn't be approved until those have been investigated properly. And
Okay.
I think there's a lot of questions about the environmental impact of this. And that would be one. I don't know what the flow rate is or anything like that because I don't have access to the property.
Okay, thank you.
You're welcome.
Okay.
Ms. Jones, you good? Got more?
I have one more
Okay.
for Mr. Surveys.
Yes.
You stated in your testimony that there are 15 endangered species on this property, but
That's-
in your in the documentation, you said that there's a potential for 15 species. So I
Right.
was wanting to know if is there
Sounds like-
endangered species, or is there maybe just because there are some in
The
Oldham
potential
County?
word was used because I could not validate that, because I was not allowed on the property. There are 15 species identified by the U.S. Fish and Wildlife that are on this property, but there's been no physical verification. So that's potential until I say yes.
Okay, thank you.
Ms. Jones, you good?
That's all.
Ms. Kraus?
Yes, if you could come back, please. So these, yeah, the species that we're talking about, said there are 9 mussel species, et cetera. And is that on the southern portion of that property that we're talking about that they're going to actually develop on? Or is that north of that in that kind of an open space?
Is there a map I can show? Okay. So anyway, my study was limited to that southern portion,
Okay.
that line of demarcation, whatever we want to call it.
Thank you.
Did that answer that question?
Thank
Okay.
you.
All right, you good, Ms. Kraus? Okay, commissioners, further questions? Yeah, Mr. Douglas.
You might want to come back up. Sorry, I'll get you therapy in today.
Hey, I need the steps. My wife says I need the steps.
Just elaborate on what you just told the
Yes.
commissioners here about the threatened and endangered species. You want to explain to us where you got that information?
Sure.
I can see where you got it from, but is it talking specifically for all of Oldham County? In that?
All of what?
All of Oldham County?
All of Oldham County. No, this is a mapped section. So what you do is you go to the Fish and Wildlife, right? U.S. Fish and Wildlife map, and you're allowed to create I'll call it a polygon, and it only examines what's in the spot, in the polygon, not anything outside. There are streams impacting that are I'll call it downstream from one of the springs, that this water, the stream, I'll call it the stream, one that runs east and west, I think, that goes into 2 separate ponds in Harrods Creek. Those species were also in that waterway, so that could be some of the additional work, but it was all related to that stream, the spring, the stream, the pond, and then dumping into Harrods Creek. I'm sorry if I was unclear about that.
So was the study done primarily of Harrods Creek
No, the study was done on the property.
on this property?
Yes, sir. On the streams.
And-
Streams, plural.
Was this a new study or just a study that was done a while back?
This is a new study. This was physically done last week.
Okay. And was there a study done on any of the surrounding properties?
No, sir. That's not what I was asked to do.
And who hired you?
Mr. Greenberg and his associate counsel. And
Would-
Sue.
Would you have done that study for that in the surrounding areas if you were trying to be conclusive? If you don't want to answer, you don't have to answer it.
Yeah, I was only hired to study the property.
Okay. All right. I don't have any further questions for you.
Thank you, Mr. Douglas.
I
Thank
do
you,
have
Mr.
more questions, though.
All right, all right. So
You're-
you get
I
to
don't
make
have any
another
more for
trip. Thank you.
It goes 50 steps.
All right.
Sorry.
Mr. Douglas, please continue.
Who was the other testimony? Mr. Wilson.
Yes.
Your background is from Where? The attorney introduced your background and your expertise.
Educationally, I have a degree in biology and a master's in environmental engineering. I've been a consulting engineer for a variety of clients for over 30 years, and then I also worked for Kentucky Waterways Alliance, which is a statewide waterways protection nonprofit.
And I'm sure I thought I heard you used to work at MSD.
MSD was a client. I was the program
client.
manager of their wet weather water quality program.
Okay.
Additionally, mentioned several volunteer engagements I've had, including the Jefferson County Soil and Water Conservation District, in which we reviewed development plans at the district back then.
So you're familiar with developmental plans
Yes.
and what needs to be done to meet the criteria for Kentucky Division of Water and the 404, the 401s permitting.
Yep.
So if a developer has to acquire those permits, those agencies, if they approve those permits, have looked at all these areas for standards, correct?
Right. Yeah.
Even when it comes to the intermittent blue line streams,
Yeah,
correct?
that'll be the main thing in
Correct.
terms of the 404 and 401 permits.
Correct.
I mean, you won't need to get them if it's not a jurisdictional water.
Correct.
So that's the first question. Is I think they've asked for a jurisdictional determination means is it covered or not? Yeah.
Correct. And that's one of our regulations they must fulfill, just like in MSD when you reviewed developmental plans there.
Sure. Oh yeah. Yeah.
So anything that you saw in your study or review about runoff, your study is based on your experience even at MSD when you approved developmental plans, correct?
Right.
Meeting the regulations that are formulated by counties or cities or
Right.
wherever they may be.
Right. Understanding that Jefferson County is different than
Yeah, it
Oldham.
is different.
Yeah, but
Longer
sure.
step.
Every county has a little bit of different approach, but sure. Yeah.
Right. And that our stormwater policy here, did you review those?
Yes, I've looked at
Our post-water construction runoffs, all the stages that must be complied by, correct?
Right.
So if developer follows all those rules, in your opinion, expert opinion, does that change anything that you've written here?
No, as I sort of alluded to, there is stormwater detention on the site, and that's going to keep the peak runoff flow below the pre-development peak runoff flow. That doesn't mean there's less runoff. In fact, there will be more runoff, and there'll be runoff in detention basins. I would say that's the conventional stormwater management approach. But nowadays, in a lot of places, including Jefferson County, you have to infiltrate water. There's a lot more requirement for holding that water, retaining instead of detaining the water on the site. So, and that's all about water quality. So we used to manage for quantity, and that's important. It's very important, but it's not enough for the streams. And we've found that if you don't manage for quality, the streams suffer. So that was sort of what the point I was trying to really summarize quickly in my few minutes.
Right. And my understanding is I didn't see anything here in your analysis or review. You did any analytic work on existing, because you mentioned about on-site wastewater disposal. Did you do any analytic work to test water in any of the areas surrounding this property?
No, I am familiar. I was working on a study of Harrods Creek, so I'm familiar with Harrods Creek and the water quality there. Just familiar with the streams in that area, seeing them. I'm one of the bikers that you all see going down that road, and it's a beautiful road. No, we couldn't, because we don't have a stormwater plan yet, we didn't have a lot to analyze in terms
But
of.
if you know our policy and our regulations, they can't exceed water flow as it exists now, correct?
I understand. It can't exceed the flow rate.
Exactly.
There will be more volume of runoff water, and it'll be poor quality.
Right. Okay.
Thank
Thank
you.
you. Mr. Chairman, I think I have a couple more questions, but
You got room? All right.
I got room?
Well, we have time, and if we run out, we'll decide whether or not we want to extend you more.
I guess I need to ask staff. There was a conversation about the Brownsboro master plan. Do we have any information on that? Is this within the Brownsboro master plan or is it just outside of it?
So it is within the Brownsboro Road Master Plan. I will add, though, in just doing research after they brought up the Brownsboro Road Master Plan.
Brownsboro.
Brownsboro.
Yeah,
Brownsboro.
Not road.
Sorry.
Okay.
Brownsboro Master Plan. That it also encompasses areas that include Crestwood Commons Apartments, the second phase of Clore Station, the Hamlet subdivision, Sanctuary Falls subdivision, as well as it lists areas that are residentially used anywhere from 1 to 5 acres of land, which were existing at the time that the Brownsboro Master Plan was approved. So I looked back in the minutes of all of those hearings, Sanctuary Falls, Hamlet, Crestwood Commons, to see if there was any evidence and testimony brought up by anybody of it not being in accordance with the Brownsboro Road Master Plan, and there was zero. There was Riverfields did come to the Sanctuary Falls hearing, but did state that they weren't in opposition to the development. They were only concerned about some type of shared path or something of that nature that was on that property. But that was it. There was nothing in any of those developments, and those are, Crestwood Commons has hundreds of apartments, 400 parking spots. Sanctuary Falls had their first phase was 58 lots on 34 acres. And then Sanctuary Falls in 22 on their second phase was 187 lots on 109.4 acres of land. So I'll just mention that for what it's worth.
Okay. I guess
Mr. Douglas has the floor.
I hate to ask, Ms. Brown, could you come up? I have one question. I think I have one question, and I'll be finished. Thank you. Can I get a clarification? You mentioned part of your farm was placed in a conservation easement.
Yes.
How many acres were placed on that? An estimate.
107 or something like that. It's half of our farm. It's about
Half. So the other half, is it a working farm?
Yes. That's
And-
the other half is used, although part of that is too, but it's used for second stride.
Okay.
And it has been used for other farming practices before that.
What is your future outlook for the other half that's not in a national or in a conservation easement?
We haven't quite decided, but it's not going to be developed.
Okay. Okay. That's all I had.
I mean, it'll probably remain as farm.
Thank you.
Mr. Douglas, anything additional? Commissioners, anything additional from the other commissioners? All right, we will move into rebuttal. Mr. Swansburg, you're up.
Thank you, Mr.
This
Chairman.
clock set, we're going to have 10 minutes for your rebuttal.
Turn all of my stuff. Okay, Mr. Chairman, members of the committee, the commission, excuse me, I got a bunch of notes here. I want to try to hit some highlights if I can. There's a lot of information that I want to address if possible. Anna, sorry, I don't mean to minimize your screens there. We had 3 experts come up here and talked about runoff and sewer septic issues and that kind of thing. And my question ultimately to ask, and I suspect has already been answered at this point, is whether or not those individuals are employed by the Oldham County Health Department. And the answer to that, of course, is no. And they actually don't speak for the health department. And the health department, by regulation, is the body that is allowed to actually come on to a piece of property to determine whether or not, at the end of the day, that property is suitable for example, septic systems. The Oldham County Health Department, in fact, did come on the property. Charlie Ward actually showed up physically on the property, drilled a whole lot of holes, and determined that it was provisionally suitable for this development. He's the only authority by regulation that is actually allowed to speak to that in terms of any type of requirement. If you allow individuals to come in and testify to or provide additional evidence at the end of the day about what they did in terms of studies, even if they didn't physically show up on the property, you're allowing to have outside entities determine whether or not a land is suitable, which the regulations don't in fact allow. The health department is the entity that gets to enter the property and make these determinations, and that's in fact what happened here. I want to make sure I state that on the record. Real quickly, we talk a lot about karst, for example. If I can put this on the overhead. This is karst potential areas in Kentucky. This is actually pulled from the Kentucky Geological Survey. It's actually available on the Planning Commission's website. Here's a big map that shows all of the areas of karst potential here in Kentucky. There's a lot of dark blue there in Lexington. I feel bad for all those people there with all that potential. We've got a lot down in, south of Meade County, Hardin County, for example, running all the way out to the western part toward the Jackson Purchase area of Kentucky. And Oldham County is highlighted on there, and there is some blue that is in Oldham County. That's correct. There's been a lot of recent development in Oldham County, and every time a development occurs, one of the things that is required is that the developer has to go to planning and zoning. They have to get permits for construction, and then an analysis is done during that construction to ensure that at the end of the day, it is suitable for development at that point as well. So again, this is not the end-all, be-all of development. There's additional processes that the developer will have to go through in order to confirm that every one of those 93 lots, if approved, is in fact suitable for developing a house on that individual lot for every single one of them. And the health department will have input again at that point, in addition to the Oldham County, the planning and zoning staff, in terms of making sure that it is suitable for an actual development before a permit is in fact issued. We talk about endangered species real quick. I'm only going to give that statement enough time just to say basically that endangered species are controlled by federal law. At the end of the day, the developer will entirely comport with whatever federal requirements there are for potential endangered species on the property, just like everyone around them who's also in the same area would have to comply with federal law with regard to endangered species. So for example, you can see on the screen, there's the map in red. The area that we're talking about of the property is the red with the little blue line south of the blue line. That's the development here. I doubt at the end of the day that there's only 15 endangered species, to the extent there are any, that are located solely on that property and not anywhere else on that map. But at the end of the day, whatever that requirement is, they're going to make sure they fulfill it. That's want to make sure I stay on that issue. We talk about sinkholes being present. Again, sinkholes, we talk about the fact that, again, when a construction permit and all the other permits that are required for construction are sought after by the county, that is an issue that will be addressed lot by lot every single time a permit is requested and sought after and applied for a development on an individual piece of property. If there's a sinkhole there, that will be addressed per lot at the time that it is actually requested, to the extent that there are any and where they might be. There was a question raised, how do we make an assessment that this place is suitable for septic? How did we make that determination? The answer, we didn't. We didn't. The Oldham County Health Department did. And they're the ones who were, again, empowered to come on that property and determine whether or not it is suitable for this type of development. And they did. And they said, yes, it is. So we didn't make any determination. The county did that it is suitable for that purpose. Conservation easement. We talk about conservation easement. Conservation easements are wonderful things. If you're a property owner, you have the right as a property owner to decide that your property should be subject to a conservation easement. And that is a right that you should exercise if you choose to do so. What that does not do, however, is empower you then to control everyone else's property around you. You have actual possession of a piece of property that does not empower you to have mental possession over everybody else that may impact you in some way. There are great things to do, and every property owner should consider that. This property owner for this particular plot has decided not to do a conservation easement, and there's no requirement that they do so. We talk about detention basins not being large enough, for example, for stormwater runoff. As Mr. Silman's already indicated, there is another process as part of this development that will have to come into play. And at that time, the county will be able to determine whether the detention basements meet the requirements. And if they need to be altered, they can be altered at that time. The applicant has put forward a proposal that contemplates detention basins in appropriate areas based upon the standards that exist in this county as promulgated by the fiscal court. That is what, in fact, the applicant has done. They've met the standards that are out there that exist. To the extent there are modifications that need to be made at construction time, that will be done at that particular time. Transportation concerns, I just want to reiterate that at the end of the day, the Kentucky Transportation Cabinet will have say over this. It is a state right-of-way, or is a state highway. They will have a say in how that entrance looks, whether there are turn lanes or not. And at the end of the day, the applicant is going to adhere to the final recommendation of the Transportation Cabinet as to that issue. Whatever their recommendations are, the final recommendations, the applicant is going to adhere to it. I want to make sure that that's stated for the record. And they will look at all those issues we talked about with safety and sight lines and trip times, et cetera, as part of that process. There was some discussion real quick about the idea that the experts who testified didn't get a chance to stand on the property and actually conduct any surveys. And that's in fact true to the best of my knowledge, unless somebody was on the property without permission, which I don't think occurred. But they weren't allowed on the property because at the end of the day, the owner of the property looked at a standard and said that the people who are allowed on the property are going to be the county health department and potentially at best at this juncture, the planning and zoning staff. The people who are allowed to be and in fact are required to be on the property in order to get approval were on that property and we allow them to be. It would turn property rights on their head if for every development you were required to have anyone who might want to have input from the public allowed on your property to conduct their own determinations of whether or not you've met particular standards of some type that they think is relevant. They're not required to be on your property. The county is required to be on your property, and they were, as again, and they determined that it was perfectly appropriate for the subdivision. So no, we didn't allow other people on there when they asked us a couple of days ago to show up on the property because they have no right to be. And all it does is generate confusion about what standards might be out there when the county has already put forward certain standards and the county has determined that this project has met those standards. Mr. Chairman, I've got 27 seconds. I suspect at this point I'm probably done talking. Other than just to reiterate again, the comprehensive plan portions that we actually talked about, which are actually in my slide, and I in fact referenced the comprehensive plan despite characterizations to the contrary, include components related to the Brownsboro area. We think it meets the plan. Thank you, Mr. Chairman.
Thank you, Mr. Swansburg. Mr. Greenberg.
I defer to Mr. House.
Thank you. To begin with, I just want to ask that the commission members please excuse my harried attempt to meet time obligations during our presentation, and please don't hold my shortcomings against my clients and the community as a whole. To begin with actual arguments in rebuttal, the health department did not look at the karst issues or the underground issues. You are the ones responsible for listening to the presentations of the applicant and the presentations of the opposition. And certainly the opposition is allowed to hire experts. Simply because they're not required for the applicant doesn't mean that the neighbors and the community can't hire their own experts and present them for your consideration. The applicant says many times that, for instance, with the Department of Transportation, we don't have that yet, but trust us, we'll get it and we'll do what we need to do. That's not the process at all. The process is to have everything. They're not even satisfying the bare minimum of the requirements that they've cited, and they've admitted that to you. They've argued that if just complying with the bare minimum is enough, and you're ministerial, which would not require you all to be here at all, but they've acknowledged that they haven't even gotten all the stuff that is typically in front of you before making a decision. That to do so would not allow the community to review and assess the veracity of what they actually plan to do. With respect to the historic house, once again, the applicant says they agreed not to tear it down, but they were coy in that. And that is that they offered no assurance that they weren't going to sell it, perhaps to another person, perhaps to another LLC, related to them or not. And then that other entity could do whatever they want to it. So there's no assurance whatsoever from them about what's going to happen to that issue. With respect to the remaining land owned by the applicant next to it, we've heard them refer to this application as phase one. That should tell you what's going on. Once again, they are coy about that issue. I'll repeat. The applicant continues to say, our plan doesn't say this or that, or provide actual statements in the record, in the application that everybody can enforce. They simply say, well, this is our intention. That is not sufficient and should not be relied upon. Question about the springs. The important issue is that this large development will create more runoff onto a property in a conservation easement that's intended to protect the water and environment. And the comprehensive plan says you should consider that. You should respect and encourage conservation easements like this that benefit the community as a whole. With respect to anybody not having access to their land, they are saying, we didn't want them there. We want to just follow the bare minimum. And we didn't want them there to find out the veracity or review the veracity of their statements, not just in the application, but what they're standing up here and telling you today, trust us. This is what's going on. This is what we'll do. They clearly just did not want somebody else reviewing what they are saying in their application or what they're saying to you now. The bare minimum is not enough. This commission is allowed to review specific applications on specific land and determine if the bare minimum is enough. Again, if the bare minimum of checking boxes was all that's necessary, there'd be no need for a planning commission. You could have a staff and review whether or not they checked the boxes, which is what they're arguing is all that matters. With respect to the other areas in the Brownsboro area, any development that's closer to a town center is probably closer to complying with the comprehensive plan. It encourages not putting development in this particular location. This is not appropriate for this particular location. We're not here to argue about other places closer to town centers. We're not here to argue about hearings we weren't present for. those hearings themselves are not applicable and not part of the evidence in this particular matter. With respect to sinkholes and how they may relate to building septic issues. If the fact that they might discover a sinkhole and then be told you can't build on this specific spot where this specific sinkhole exists is not the real question. That doesn't address how all of the water still going off of this large development, off the roads, off the rooftops, off the driveways, off the sidewalks, how all of this development is going to impact the water that flows not only through that sinkhole, but through other means. In fact, all of those septic systems are designed to put that waste into the ground, and you've heard expert testimony about the subsurface. And again, the applicant acknowledges the bare minimum doesn't require the health department to look at that issue. And that issue is clear. This will create runoff onto the preserved property. I'll reiterate, the conservation easement itself is required by the comprehensive, the conservation easement is required by this planning commission to be protected and encouraged. It benefits the community as a whole. With respect to not allowing us on the property, and that's no big issue according to the applicant, as this commission knows, the process itself for the planning and development requires upfront that the developer meet with the neighbors in an attempt to answer their questions and perhaps work some things out that you don't have to deal with. That's the process itself, to try to avoid some issues. Clearly, that's not what they want. That's not their spirit. They were working against the opposition, trying to prevent them from having any sort of ability to review the veracity of their statements. Finally, the applicant fails to acknowledge that the comprehensive plan is part of the rules that govern development. In fact, it's probably the most critical part because that's where everybody meets every 5 years and they discuss what are the important things we should consider here in Oldham County? What do we want for the future? Where do we want development? When an applicant provides an application, what should we consider? Is this something that is going to encourage the type of county that we want? Part of the process is, where is it located? Is it located closer? Are there better places for this type of development? Is this development too large for this location? Does this location have particular equities, particular facts that are associated with it that require us to consider and that would indicate that this development is simply not appropriate for this particular location. The applicant doesn't want you to look at the comprehensive plan, which dictates everything about how development should proceed in Oldham County. The applicant doesn't want you to look at the comprehensive plan. They want you to look at the bare minimum of the application. They don't want you to look at the comprehensive plan because this flies in the face of the comprehensive plan. This in no way satisfies the goals and intention of everybody that discussed and signed off the comprehensive plan. Thank you. That's all that I have.
Thank you. And we will now move into final statement. Opposition's up first.
Bear with me. I've been asked to reinforce an issue that I had intended to cover in my original presentation and wasn't able to get to in light of the time considerations. The subdivision regulations confirm that if a requirement, it expressly states that if requirement any requirement in the regulations or in the application process is in conflict with anything else, including the comprehensive plan, it's the most stringent thing that applies. And so the comprehensive plan must be followed if it tells you and dictates that this is the wrong place for this development, that it dictates you must consider conservation easements. You must encourage them. You must consider the specific properties of the neighboring lands. You must consider what sort of area is this. This is a rural area filled with farms. Yes, there are some developments in there with much larger tracts than's proposed and with fewer homes. That's what's proposed. You heard from a developer earlier today in opposition to this about similar farms in similar locations, and he didn't propose to fill the bulk of it up with tracts that are small tracts and large numbers of houses. 93 on this location. Other developers have chosen to do the appropriate thing, follow the comprehensive plan, and put for you an application that might make sense. That's not what happened here. They're shooting for the moon. They're going to destroy the character of this area. They didn't take into consideration anything in the comprehensive plan. They've told you that themselves. They don't consider that important. It's not for them to review, and they don't believe it's for you to review. That is just false. The subdivision regulations also state that every issue about environmental harm must be considered. Period. That's a requirement, even in the subdivision regulations. It's also covered in the comprehensive plan, but it's also in the subdivision regulations. I would once again tell you, despite all the efforts from the applicant to ask you and to actually try to instruct you not to consider the comprehensive plan and its requirements because it must be considered. Despite their arguments otherwise, please consider the comprehensive plan. Please consider what the community believes Oldham County should look like, because the community was a part of that process of approving the comprehensive plan. They provided input. The community as a whole in Oldham County agreed that the comprehensive plan describes the nature and character of what they want this community to look like. This flies in the face of that. I know you have a lot of difficult decisions. If you review the comprehensive plan, this is not a difficult decision. It should be rejected.
Thank you. Anyone else from opposition? Hang on, Mr. Swansberg. You have additional time if anyone else wishes to add on to the final statements.
I would like to add just one thing.
Your name again for the record, please?
Barbara Hartung.
Thank you.
You need the address again?
No, ma'am. Thank you.
Most of the testimony today has been about the environmental issues and the environmental concerns of the neighbors. I specifically want to point out to you Section 5.9 of the subdivision regulations, that it says, as council said, all relevant information about possible environmental harm is to be considered. But it goes on and it adds, if questions remain concerning the development's impact upon the environment, then the proposed development should not be approved at this time. Clearly, we had experts come and raise questions. There were no experts who refuted them. Under the subdivision regulations, what needs to be done is there needs to be further analysis. If you look at the regulation, you will see that's what it says. Have the developer do further studies and further analysis, and then come back to see if it should be approved. Thank you.
Thank you.
10 seconds. Mark Fackler. Mr. Ward is not here to ask about his consideration of chemical. I asked him at the TRC about PFAS, and he said he did not have any knowledge of that, and he's not here to ask questions, which I think would be very pertinent.
Thank you. All right. Mr. Swansberg, final statements, please.
Mr. Chairman, members of the commission, we had a really good conversation today about this proposal, and I really appreciate the comments, the input, the concerns raised by individuals who are particularly excited about this proposal. And I understand that, and I respect that. Every subdivision proposal in this county, as we all know, is met with some level of skepticism, some level of concern, some level of opposition. And when we talk about each one of those proposals, we look at a series of standards, and we look at a series of proposals put forward by the applicant and the developer. We receive input from those who are not in favor of it, and then we make a determination. But the determination ultimately is one that is done based upon a set of standards that are promulgated by the county through the fiscal court and are then applied to each individual application. This is not necessarily the purpose of conclusion, but I do want to make sure I state for the record, Mr. Chairman, members of the commission, the applicant, in fact, did have an expert come out. We had an expert company called Res LLC that actually came out to the property and conducted a pretty significant inspection of the property and an analysis. What I did not want to do today is get into a war of experts and just figure out if we just had 4 instead of their 3, then we might have actually carried the day, or their 5 versus our 4. And we just end up getting into a battle of experts over what the standards might be, when the standards, in fact, are clear about what the decision at this point can be and who gets to make that decision. And as I've indicated before, that decision at this level gets to be the Oldham County Health Department, and it gets to be the staff when we propose to you all a development plan and whether or not at this stage it meets the criteria for continuation of a proposal. There will be, assuming approval today, additional processes that will have to be scrutinized by the county, by individuals who are empowered to look at the concerns that were raised today and to make a determination moving forward about individual developments. That's how the process works. That's how it works in every subdivision plan application. I want to make sure I pull up for your benefit here. Conclusion on this. We are respectfully asking this body to give final approval to a preliminary plan for the Triple Springs subdivision. Pine Grove subdivision. Triple Springs Partners LLC is the owner and applicant. The Pine Grove subdivision without the need for any waivers, any variances, or any changes to the Oldham County zoning map. It adheres to the Oldham County Comprehensive Plan, which I have discussed as part of my presentation and as part of my rebuttal, and I will discuss here as well. It adheres to its admonitions to ensure complementary and compatible growth with other areas. As we demonstrated before, there are developments that surround this property that are similar in nature to this property in terms of lot size, septic system use, and location. B, limit the impact on the environment through approved septic systems and stormwater retention efforts. Again, the minutes reflect from TRC that the Oldham County Health Department went into this property. They dug appropriate holes all over the property, 40 holes worth, and found it to be entirely provisionally suitable for this purpose. Stormwater retention efforts, again, we talk about the idea that part of the plan and part of the efforts that are going to be after this are going to address that issue, but they've already been addressed in the plan. And as far as we're concerned, we are either meeting or exceeding the standard of everyone else around us in a similar situation. And we also talk about protecting historic sites to the extent practicable. We've talked about the house. I don't need to talk about the house anymore. But the representations made should suffice to be enough. Protect the character of the social and economic stability of Oldham County and promote orderly and beneficial development. Protect and conserve the value of land upon Oldham County, throughout Oldham County, the value of buildings and improvements upon the land, and minimize the conflicts among the uses of land and buildings, and to utilize public facilities which are available and which will have sufficient capacity to serve the proposed subdivision upon its completion. All that has been addressed. All of these are in the comprehensive plan. All of them have been talked about by the applicant. Final point. There is no need for a discretionary act, ladies and gentlemen. There is no change otherwise. We would argue this is a ministerial function, and we would ask respectfully for your approval of this proposal. Thank you, Mr. Chairman.
Thank you, Mr. Swansberg. All right, commissioners. First thing we're going to do here is we're going to hear from council and staff to frame this up, and then we're going to take a short break. During that break, you will have the opportunity to discuss with council or staff if you have any considerations for a motion that you wish to bring. So, Mr. Fisher.
All right, and I may need Ms. Barge to pull up the binding elements off of her slide because I don't believe the KYTC one was in our staff packet, so.
No, we added it at a later time because the packets were ready a week before.
All right. So you've heard evidence and testimony, considerable amount from both sides. You've heard about the goals and objectives of the Oldham County Comprehensive Plan. On page 2 of your staff packet, you do have suggested motions to both approve and deny this preliminary subdivision plan. Once again, in accordance with the evidence and testimony you've heard, compliance with the goals and objectives of our comprehensive plan, as well as our subdivision regulations. In addition to that, you have 5 proposed binding elements. 4 of those are on page 3 of your staff packet. Those do include that the approval applies only to the plan presented at the March 25th, 2025 Oldham County Planning Commission public hearing. There should be no subdivision of any lot into a greater number of lots without review by the Oldham County Planning Commission. The preliminary plan must comply with all established federal, state, and county ordinances and requirements at the time of construction plan approval. 35, and I changed lots to building permits per year because that's actually what you would get per year, not necessarily lots. 35 building permits are allowed per year per the Oldham County Board of Education. And then the 5th one is the developer must comply or must follow KYTC requirements related to roadways and traffic.
Mr. Swansberg, do me the favor of acknowledging those
We
conditions
acknowledge
of
those,
approval.
Mr. Chairman, members
Thank
of the
you.
commission. We also agree to all 5 of those binding elements.
Thank you, sir. All right.
Mr. Commissioner.
Council, do you have anything?
The only thing I would caution, Mr. Chairman, and you know, we get the motion making at every one of these meetings, and I would caution everybody that any motion that you make has to be related to matters in the record, matters that you heard testimony about today. I would ask that any motion be specific about things that you find in support of your motion. So if there's a motion made to approve or a motion made to reject the development plan, specific facts should be cited from the record.
Thank you, Mr. Baxter. Mr. Douglas, did you have something?
I think Mr. Commissioner Hampton had some questions with Mr. Jones and the applicant regarding the registry, the National Registry of the house, existing house. Should we put something in the binding element to assure that house, or can we? On the
My initial response is that the 3rd of the proposed binding elements, compliance with all established federal, state, county ordinances, covers that subject matter. Council, mistaken, correct? Tell me.
I think you're correct, Mr. Chairman.
Sounds good.
We good? Okay. All right, guys, we're going to take 5. All right, thank you, everyone. We'll come back to order at this time. So, at this moment, floor is open for motions. Commissioners, who would like to bring forward a motion in connection with this document? Mr. Marsh, is that you?
Mr. Chairman, let me start here. In regards to docket PZ-25-008, I move to approve the preliminary subdivision plan because from the testimony here today, it meets all the requirements listed in the comprehensive plan. Mr. Silman and other staff testified that many of the concerns will be addressed in further processes as this is moved forward. And this does benefit the county in the way that is presented and requested by the comprehensive plan. And I also move that we include the 5 binding elements as presented by Mr. Fisher.
Thank you, Mr. Marsh. Council.
Mr. Marsh, you mentioned Mr. Silliman. Does that also include the testimony of the other staff members? That
Yes, Mr. Silliman and other staff, please.
With that addition, Mr. Chairman, we have an adequate motion.
Thank you, sir. We have a motion on the floor. Do I have a second?
I second.
Ms. Davis, thank you. All right, Commissioners, discussion? Seeing none, we'll move into roll call vote.
Mr. Douglas.
Yes.
Ms. Kraus.
Yes.
Mr. Marsh.
Yes.
Ms. Jones.
Yes.
Mr. Hampton.
Yes.
Mr. Fox.
Yes.
Ms. Davis.
Yes.
Mr. Elder.
Yes.
Mr. Klingenfuss.
Yes.
Ms. Walzer.
Yes.
Thank you, Ms. Edgar. And the motion to approve PZ-25-008 has been approved on a vote of 10-0. All right, Commissioners, moving into next. Or are we going to break? All right. Commissioners, before we take up the next docket item, Commissioners, we're going to break for a bite across the hall. Okay, guys? 45? 45 minutes? 45? Okay, yeah, 5 after 1.